Good morning, ladies and gentlemen. Thank you for joining us today. The meeting will now come to order. Welcome to this meeting of the Charlotte Unified Development Board of Adjustment on Tuesday, May 26, 2026. My name is Deborah Dryden, and I am chair of the board. Would the board members please go around and state their name for the record?
Marshall Williamson.
Devin Shea.
Amy Ling-Sun.
Hamilton Court.
Thank you. Also present are John Kinley, our interim zoning administrator and senior project manager, Crystal Monsegur, our planner, Kamisha Lampley, clerk to the board, Teree Hagler-Gray, senior assistant city attorney, advisor to the planning staff, Paige Inman, assistant city attorney and advisor to the board, and Elizabeth Majors, our Veritex court reporter. Each of today's hearings is a quasi-judicial evidentiary hearing. That means it is like a court hearing. State law sets specific procedures and rules concerning how this board must make its decisions. These rules are different from other types of land use decisions like rezoning cases. The board's discretion is limited. The board must base its decision upon competent, relevant, and substantial evidence in the record. A quasi-judicial decision is not a popularity contest. It is a decision constrained by the standards in the ordinance and based on the facts presented. If you will be speaking as a witness, please focus on the facts and ordinances standards, not personal preferences or opinion. General witness testimony is limited to facts. For certain topics, this board needs to hear opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts of increased traffic. Individuals providing expert opinion must be qualified as experts and provide the factual evidence upon which they base their expert opinions. While hearsay evidence is not specifically excluded, it is only given limited weight. Parties with standing have rights to participate fully. Parties may present evidence, call witnesses, and make legal arguments. Parties are limited to the applicant, the city, and individuals who can show they will suffer specific damages. Other individuals may provide testimony as witnesses when recognized by the board. Witnesses must swear or affirm their testimony. Any individual wishing to speak as a witness today was required to sign up. If you haven't done so, please do so now. The parties to each case are entitled to an impartial decision maker. A board member may not participate in a hearing if they have a fixed opinion about the matter, a financial interest in the outcome of the matter, or a close familial, business, or associational relationship with an affected person. The parties to each case also have a right for any ex parte communication to be disclosed. Ex parte communication is any communication about the case outside of the hearing. That may include site visits as well as conversations with parties or the general public. At the start of each case, any potential conflict of interest or ex parte communication should be disclosed by a board member if applicable. These matters may also be raised by any affected party. Today's meeting will follow the order printed on the agenda. The order of the regular agenda will be as follows. All parties who plan to give testimony must be sworn in. A city staff member will present a summary of the case. The board may question the staff member, and then the applicant may question the staff member. The applicant presents their testimony for the case, and any sworn witnesses provide testimony. The board and staff may question the applicant and their witnesses. Other parties wishing to speak for or against a case will be given reasonable time to present sworn testimony. The staff and then the applicant will be given an opportunity for rebuttal. After hearing each case, the board will review each case and render a decision. This is usually done in closed deliberations after hearing each case. The chairperson calls for a motion and a second to approve or deny the variance or the appeal. In the case of an appeal, the chairperson shall call for a motion and a second to uphold, modify, or reverse the administrator's decision. The decision will be made by a simple majority vote of the board. However, the board may elect to take up to 30 days to render a decision. You may remain present during the deliberations, or you may call the zoning staff after the session to receive the decision of the board. If you wish to receive a written copy of the decision letter, please indicate so on the sign-in sheet. All exhibits must remain with the board. If your cases are not appealed to Superior Court after 30 days, you may pick them up or they will be destroyed. Appeal from this board is to the Mecklenburg County Superior Court. You have 30 days from the date of the board's written decision in which to appeal in accordance with NCG 6 GS 160D-405D. Okay, at this time, I will administer the oath for individuals who intend to provide testimony. So if the staff will please, okay. Do you solemnly swear or affirm that the evidence you shall give to this board in this action shall be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Thank you very much. Okay, we now open the evidentiary hearing for, before we, we're opening the hearings, but we are, if you'll look, board members, at the other agenda items on the back of our agenda, we are going to there are 4 variances that have been requested postponement until the July 28th meeting. That's variance 2025-00050 for property located at 620 Queens Road. Then there's an appeal of 2026-00003 for property located at 2424 Cedar Vale Drive. There's a variance request to be deferred from, it's variance 2026-00022 for property located at 9365 South Boulevard. And finally, a request to be deferred for variance 2026-00026 for property located at 2500 East Fifth Street. Do I hear a motion to approve?
Mr. Hyde, before y'all do a
Yes.
motion, just real quick for the record, I want to just basically describe what each one is deferring or reasons for their deferral. The first case, 2550, that one is they had put on hold while they evaluated their options, whether or not to continue forward with the variance or not. And it sounds like they're going to be coming back to get put back on the agenda for next month.
Okay,
So they're ready to move forward. And then the appeal case from Mr. Murray, 2603. That one, they're still evaluating what options that they can potentially use to resolve it without having to come through the board for an appeal. And then 2622, staff had asked them to make some revisions to their plans, and that request was like a week before this meeting. So they asked that they asked if they could defer so they could have some time to work on those revisions. And then the last one, 2026, the applicant that Ms. Beeson is representing is out of town this week, so they asked to defer it to next month.
okay. All right, board, do I hear a motion to defer 3 variances and 1 appeal until the July 28th meeting?
Move to defer.
Okay, thank you, Mr. Court. Do I hear a second?
Sun second.
Ms. Sun, thank you very much. All right, Mr. Williamson,
Williamson, yes.
Mr. Shea,
Say yes.
Ms. Sun,
Yes.
Mr. Court,
Court, yes.
Dryden, yes. So these 3 variances and 1 appeal are deferred until the July 28th, 2026 meeting. Thank you very much. All right, back to the recommendation agenda. We now open the hearing for variance number 2026-00020. The property is located at 13115 Foxbury Road. Before we begin, does any board member have a conflict of interest or personal conflict or ex parte communication they need to disclose? Hearing none. Staff, you may begin.
Thank you. Good morning, board. Good morning, everyone.
This is case variance 2026-00020 and is to reduce the minimum required driveway length and garage setback. The applicant is Eastwood Construction Partners LLC, represented by Mark Batiste of Eastwood Homes for property located at 13115 Foxbury Road, and is owned by Eastwood Construction Partners LLC. The variance is from Article 19.6, A1, Roman numeral 3, C and D, to reduce the minimum required 20-foot driveway and parking pad length and the minimum 20-foot garage setback from 20 feet to 17 feet, which is a 3-foot reduction. Exhibit 1 shows the vicinity map where it's pretty much located. It is located about northeast of Charlotte, close to 485. Here's an aerial map showing the development. And just so you know, it's in the Codwell Forest subdivision off of Codwell Road. And it's an approved conservation residential development. So they encourage protection of open space and natural resources as alternative development standards. The zoning is N1A Neighborhood 1 zoning districts, shown in Exhibit 3. Here is an image of the site on a street view. It is a little outdated because there are some houses built. And like I mentioned before, this variance is to reduce the minimum required driveway parking pad length and the garage setback from 20 feet to 17 feet, a 3-foot reduction. So the reason why they're requesting a variance is because on the left side, you can see this was the approved LDIRL where they were compliant. It was 21 feet is what they were proposing for the driveway length, which would have been in compliance. But due to a surveying error on the right, this was the as-built and what was actually built. And it shows 3.3 feet was encroaching and brought it to 16.17 feet instead of the required 20. And the reason why they're asking for 3 feet is because we have something called a fractional rule that if it's 16.7 feet, we round it to 17 feet, which they just need 3 more feet to meet the 20. Here are images of the home, just to show you how it encroaches a bit. But if you kind of compare it to the house next door, it doesn't encroach that much. It's not like very visible. On the top part, you'll see we did some research where what is the average length of a car and would it fit without being on the sidewalk part. And the compact vehicles are about 10 to 14 feet. And it goes all the way up to 18.4 feet long, but that's like a big SUV truck, which is not very common, but it would pretty much fit to what they're asking for. These images in Exhibit 8 shows kind of the houses next to it in comparison. So you see that's the one in the middle and how it compares to the other ones. Just to kind of show you a comparison that is not going too much over. Here are the variance criteria in Exhibit 9, giving you a chance to look over findings of facts.
Do we know when this was caught?
When this was caught.
Is the applicant here?
Yes, the applicant is here. And
That does not know.
I'm checking. It was there was no violation that was happened. They realized it on their own and they came to us to try to get that relief. So
Yeah, at foundation, after a friend, when? I mean, when? The reason why I'm asking is because in the application, it's very obvious to anybody on the street that house is sticking out farther
Mhm.
than the other ones around it.
Mhm.
It's very obvious to me.
Okay.
So I'm just curious to know when it was caught.
They did an as-built survey at the conclusion of the construction, and the as-built survey revealed the encroachment.
So at the end.
Yeah, it went through all the inspections by, city staff and building inspectors and that, and it wasn't brought up until they did the as-built survey.
Okay, Crystal, you may continue.
Thank you. Because to meet the ordinance requirement, the structure would have to be modified by removing 3 feet from the front of the garage portion of the structure. The garage is about 20 feet deep, and reducing its depth to 17th while still functional will limit its usability. In conservation residential development, the front setback for the principal structures is half of the base ordinance standard. In a traditional N1A development, the front setback for the principal structure is 27 feet. Within the conservation residential development, the principal structure is set back and reduced to 13.5 feet. However, the garage setback and driveway length are not modified, they remain at 20 feet. All proper LDI reviews were completed, permits were obtained, and the inspections were completed by the city and county. The error became apparent with the completion of an as-built survey which showed the error that had occurred. The hardship results from conditions that are peculiar to the property. Because the home construction was completed under approved plans and the builder relied in good faith on staking completed by the surveyor. The structure is 16.7 feet from the back of sidewalk, and the portion of the garage that extends past the 20-foot setback line would have to be removed in order to comply. The hardship does not result from actions taken by the applicant or property owner. The applicant in good faith relied upon the staking completed by the staking surveyor. The need for the variance is a result of a surveyor error that led to single-family detached home being constructed 3.3 feet closer to the front of the property line / right away than required by the UDO. The surveyor staked the building box for the applicant. The applicant states in their application that the surveyor was instructed by the applicant to place the setback at 20 feet because of this 20-foot garage setback rule. However, the surveyor placed the stakes in error. The requested variance is consistent with the spirit, purpose, and intent of the regulation, such that public and substantial
Safety.
justice is achieved, excuse me. The requested variance is limited in scope and represents the minimum relief necessary. The 3-foot garage encroachment does not negatively impact the adjacent property owners. Traffic visibility, pedestrian safety, utility access, drainage, or neighborhood character. The average passenger vehicle length is 16 feet, and the majority of vehicles will fit on the 17-foot long driveway pad without encroaching into the sidewalk or street right-of-way. Per the Charlotte Land Development Standards Manual, CLDSM, parking spaces ranges from 15 to 18.5 feet in length. As demonstrated in the photos submitted by the applicant, the encroachment is not obvious from the street. The completed home remains fully compatible with the surrounding new homes in the development and maintains the overall streetscape and design of the intent of the subdivision. At this time, no notice of violation has been issued. The applicant voluntarily brought this request forward to resolve the issue because the new home is for sale. The requested variance is minor, only 0.9 feet beyond what could have been granted by an administrative adjustment per Article 37.4 of the UDO. Granting the variance would not alter the essential character of the neighborhood. And here is the sign posted on the property in Exhibit 13. May I take any questions or show you the site, the plans again?
Keep saying 0.9 feet. I thought it was 10%. You guys have 10%.
Yeah, there's 10% or 2 feet, whichever one is greater, is what we're allowed. So when we did the 10%, it would have just need 0.9 for us to be able to do it administratively instead of a variance.
So that'd be 18 feet. And these guys are 3.3 feet closer than that, so they're 1.3 feet closer. We're getting 0.9. I guess it's not important, but I just don't understand where 0.9 is coming.
Let me see.
Well, they could grant 10%,
Which is 2 feet,
right, but it's 0.9% over that.
0.9 feet or 0.9%.
0.9%, it says,
9 feet. That's what
9
we wrote,
feet.
0.9 feet.
The 16 point, yeah, 16, I don't know if we did our math right. It's 16.7
which is
encroaching, which rounds up to 3. Basically, they're a foot short beyond what we could grant administratively.
Okay, John.
well,
Yes.
I'm confused. I mean, I'm not confused about what's written on the paper, but a caution, because it says on here, it's nobody's fault except the surveyor. Well, excuse me, you're building all these houses in a row. I don't understand how this house got missurveyed when you have a house on the left and a house on the right. These look exactly the same. The lot sizes are the same. And I know we don't ask permission, we beg forgiveness. I get all that. And I'm not saying that the board will not discuss approving this variance, but it bothers me to sit here on this board and have people consistently come forward going, oh, well, it was the surveyor's error. It's not my fault. It was the surveyor. But what we say to homeowners all the time, ultimately, it is your fault because you're in charge of this. And I don't understand how you don't notice that it's out of line when you poured the pad or when you started to build the house. It wasn't noticed until you did the final survey, completion of an as-built survey, and then it was, oops, we did this wrong. Builder, pay attention to what your surveyors are doing, is what I'm saying. As the chair of this board, it exasperates me that you come with these, it's not my fault, it's not my fault, it's somebody else's fault. And then you come to us and say, well, help us fix it, because it was really nobody's fault. Did you hold this survey company to task for this? Did you say to them, what in the Sam Hill are you doing out here? Or is it just, well, the survey made a mistake, he's having a bad day? This absolutely infuriates me as chair of this board. That, I mean, it's not a lot, no. But in retrospect, it is a lot. Because what happens when the surveyor comes and the next house, 6 houses down, the pad's not right? Are you going to come back to us again and say, oh, well, we just need this 0.9. We really didn't mean to make this mistake. That's all. I'm done. All right. Comments from the board, ask questions for staff.
Could you go back a couple of photographs? It was, yeah, that, on the bottom left picture, we're talking about the house, the second house.
That
Yes.
one, yeah.
And so tell me about the third house. That looks to be in line with this one,
Like the first one.
with the one in question. Is it
Well-
gonna be in next month's variance?
Well, if you look at the top left, it doesn't look as, you can kind of see where that middle one juts out. I think it's the way the picture was taken that makes it look like it's in the same. But that's my point. If the surveyor made this mistake on this lot, what's not to say that they made the mistake on 4 lots down? or 5 lots down, and that we're gonna be back here in 2 months going, oh, it was just a little inch. We didn't mean to do that. That's what infuriates me, because it says here, it wasn't the builder's fault. It wasn't, the error didn't occur. The surveyor staked the building box for the applicant. The surveyor placed the stakes in error. But ultimately, builder, you are responsible for all of your subcontractors, for your surveyors, for your concrete people. So don't come to us and say, oh, gee, it's not my fault. It was the surveyor.
Is the rear yard?
Impact.
Rear yard, is there plenty of room back there?
Yeah, so of what was approved was 49.3 feet in the rear in the house. And the as-built shows that it's 53.6, so they had some increase in the yard.
So they're not squeezing it forward to overcome some rear yard problem.
I didn't hear anything about that during the application and when we discussed it with the applicant.
Just remember, if anyone feels like they might vote against it, we need to take it off the recommendation agenda and let the applicant present.
What do you say, board? You want to hear from the applicant? Do we need to move it to the recommended agenda?
Yes,
I make a motion to approve it.
Alright.
I second.
Okay, so, Mr. Williamson has made a motion to approve. Mr. Shea has seconded. Before we vote, I'd just like to say to staff, I would prefer not to see this incident come back to this board with this developer. Because it's my feeling that if I vote for this, which, I mean, I don't want them to have to tear down the garage. But we put these things in place for a reason. And if in 6 months, this board is, you're gonna face this same issue, oh, it was the surveyor. I mean, there needs to be something in place with inspectors if they're looking, I don't know what they're looking at. I don't know if they're measuring when they pour the
It's
pads.
not the inspector's job.
It's not the inspector's responsibility, so strictly it's the builder. Because the next time it might be not this little bit, it might be more. I don't want this to come back to this board. Developers, I'm talking to you. Don't bring this back to the board. Look at your surveyors, talk to those people, hold them accountable for this. Because it's not our responsibility to fix your mistakes. But that's basically what we're doing. Okay, Mr. Williamson has made a motion to approve. Mr. Shea has seconded. Mr. Williamson,
Williamson, yes.
Mr. Shea,
Shay, yes.
Ms. Sun,
I have a question.
Oh,
Who's the surveyor is? Who are the surveyor for this? Is it the same surveyor as the last case?
I don't have that information in front of me.
It's on
Did
the,
not research that prior to
It's
the
on there?
it's on
meeting.
the application.
It's-
It's stamped on the application.
okay, all right. No, that's.
Did you
minutes from
want me to
last
take a
month.
moment to look for
anything.
that information?
Anything?
Mm-mm. No, we don't, all we have are the finding of facts and conclusions of law, and it doesn't list that.
Okay.
Probably on the paperwork that they sent you, they emailed you. It's on that. Okay, so,
Ms. Dredden, can we close the public hearing for this matter?
No, it's fine.
no, it's fine. She's okay with it.
We still need to close it so that the matter is,
Oh, okay,
we just need to announce that it's closed.
okay, all right. Well, we've closed, yes, the public hearing. So now we're in deliberations, and that's where we are. Mr. Williamson has made the the recommendation to approve. Mr. Shea has seconded. We're to Ms. Sun. Do you approve?
Yes.
Mr. Court
Court, yes.
and Dryden, yes. So the request is approved. All right. All right, we're moving on
Yeah.
to,
Finding the fact.
yes, the finding facts and conclusions of law. I don't,
Do we need to change number 19?
just for,
It should be. Should be 1.25 feet, should it not?
Crystal. She's looking, she's figuring right now.
Okay.
Burn that calculator.
Well, we're looking at number
19,
19.
should we change it to 1.25 feet to be correct? Thank you.
So for number 19, the requested variance is minor, only 1.2 feet.
1.25 feet.
Beyond what could be granted by a 10% administrative adjustment.
Oh, then it would be 1 foot then, right? So technically it would be 1 foot, because they could take T.
Okay, 1 foot.
Administratively, we can do 2 feet off of the 20 to bring it to 18, but they need to bring it down to
Oh, no,
basically 3 feet because of the rounding, the fractional rounding rule. So they're a foot off, basically. So 1 foot.
So a foot.
So 1 foot.
Yep.
So 19 should be 1 foot.
The requested variance is minor, only 1 foot. Okay. Did you get that, Elizabeth? We're mumbling here. All right, the requested variance is minor, only 1 foot beyond what could be granted by a 10% administrative adjustment. All right, do I hear a motion to approve the finding of facts and conclusions of law as amended?
Move to approve as amended.
Thank you, Mr. Court. Do I hear a second?
Second.
Thank you, Ms. Sun. Mr. Williamson,
Williamson, yes.
Mr. Shea,
Cachet, yes.
Mr. Shea, sorry. Ms. Sun,
Son, yes.
Mr. Court,
Court, yes.
and Dryden, yes, as amended. Finding of facts and conclusions of law are approved. All right, thank you very much. All right, the next variance number 2026-00023.
No. we'll move
We
it.
are moving that to the regular agenda because there's opposition, so we will skip that one right now and move to variance number 2026-00025 for property located at 17932 Snug Harbor Road. Is there anyone that needs to recuse themselves off the board for a potential conflict of interest? All right, hearing none. Okay. Who's presenting this case? Okay, thank you.
Mr. Shea, I did find that critical protected area stuff. So if you want to go through that, we can, if you want, or if you want to ask, later for informational purposes, that's fine.
No, I just need to, oh,
Which survey company is it?
I didn't recognize. Somebody before.
Maybe, yeah.
no, I said I'm old. That's all. No, yes, it just makes me angry.
No.
No. You would have never guessed, would you?
Ready?
Yeah, we're ready.
Okay. Thank you. Good morning, morning again. The case number is variance 2026-00025. And the applicant's requesting a proposed ADU accessory structure in the established front setback. The applicant is Vincent Chevier, represented by Sarah Beeson of Alexander Ricks PLLC, for property located at 17932 Snug Harbor Road, owned by Vincent and Jamie Chevier. Variance from Article 17(1)(e)(1) to allow an accessory dwelling unit, which is an ADU, to be located in the front established front setback. The location, it is all the way down here, which is Southwest Charlotte, right on the Lake Wiley. Here's an aerial map view in Exhibit 2, and it shows the existing house that's going to be demolished. And just to let you know, this house was built in 1963, and it's on a buffer. And I'll show you in the next few slides. Okay, so there's a 50-foot swim buffer, all this yellow part of it. An existing home falls on the buffer, and it is approximately about 150, 151 feet from the right-of-way. The zoning for this is N1C Neighborhood 1 zoning district. In this bird's eye view, want to show you a few things. This is the existing home to be demolished. This is where they're proposing the accessory structure to be in the front. And just to let you know, this is the right of way, but the edge of pavement is about 155 feet. So I'm going to scroll a little bit to show you an image of what we're talking about. So right of way, edge of pavement, excuse me, so it's about 150 feet. So you can't really see the front. You know, it's pretty far is what I was trying to depict there. And then just to let you know, there's the adjacent home neighbor, they have an ADU accessory structure in the front as well. So they wouldn't be the only people in the neighborhood having that. The variance is to allow the accessory dwelling unit to be located in the front setback. And here is the part of the code where, they mention it. A lot going on in this slide, but once again, that swim buffer, that's that dotted line. The proposed new home is right here. It's going to be located outside of that buffer, which means that it was 155 or 151 from the right of way, which was compliant. Now it's going to be 95.6 feet, which is not compliant. But from the edge of pavement where you actually can see the home, it's 250 feet. And then as far as the proposed ADU, it's only 35 feet from here. It should be 50 feet. But to the edge of pavement is 176. So just to kind of show you that even though it appears close, there is a bit of a buffer that shows it's farther away.
Is that the swim buffer, was that established, I'm assuming after that original house was built?
I would believe so, because it was 1963 when the house was built, and they have been changing since then.
So now in order to be in compliance, they need to move the house.
Yes.
It's not a swim buffers. It's not a swim, it's a lake, it's a lake.
A lake.
It's a lake center. Swim buffers.
Yeah, lake buffer. Thank you for
Just swim crystal clear.
Yeah.
There were two things that you notice in the agenda. It says the variances for ADUs. But there are two variances being requested, one's for the house and one's for the, no.
it's mostly for the ADU.
You just mentioned that the
Yeah,
house is 95 feet.
Yeah, that which means it's not compliant.
The house is compliant with its setbacks. See number C, letter C on the board, on the screen. So the ordinance says that if you can have an accessory structure in front of your house in the established front setback if the principal structure is set back more than 150 feet from the right of way. And then then that accessory structure has to be set back 50 feet from the right of way correspondingly. In this case, because they're having to move the house forward to get out of the lake buffer, that brings the house closer to the right of way. So they no longer would be able to meet that 150-foot requirement, whereas the existing house technically would. So the variance request is actually to the accessory structure. We're saying ADU, but it's an accessory structure because it's got a garage and a ADU in it. It's not solely an ADU. But so the variance is to the accessory structure to allow it to be within that established front setback, where otherwise it would have to be in the side or rear.
Thank you for the clarification. I definitely could have explained that better. Thank you for asking. And here's just some more going on. This is topography. So over here, we're at 600 feet. And then we're here at 570, 580. So there's about 20 feet, more or less, of slope going on there. These are images the applicant provided to us. This is the images of the rear of their home. And I believe that, you know, that what's depicting here is that slope, you know, with the topography. That's what these images are here for on Exhibit 8. And we're gonna get into the findings of facts.
Far away is the accessory structure from the main house?
From the main house.
I mean, when they build a new house, how far away is this accessory structure in the big?
Yeah, so this is it, and then,
Within walking distance?
yeah, well, here's the corner of this, and then here's the house. So I don't have a measurement for that, but visually, that's the distance, if that's helpful at all.
Talk about critical watershed. Mike, that P. Lake Wiley is all something different than Mount Island Lake. So it's called, well, it's called Lake Wiley Watershed, right? CA Lake Wiley Watershed, which is different than CA1, CA2, and CA4. We like to go the differences.
I'll do my best to explain it. So in the Charlotte jurisdiction, we've got Mountain Island Lake, Lake Wiley, and Lower Lake Wiley. So those three lakes each have their own critical watershed area and protected watershed area. So CA is critical area, PA is protected area. So on Mountain Island Lake, you have CA1, which is a certain area of the lake based on the drainage areas and the creeks that drain into it. And then you have CA4, which is the area along the lakefront itself. And those are both within a half mile of the lake. Then you have the protected area on Mountain Island Lake Watershed, PA1, and that is basically 5 hydrologic miles. So basically following the streams 5 miles inward or landward is that area. Then for Lake Wiley, you also have critical area and a protected area. The critical area is 1/2 mile inland from Full Pond. And then the protected area is 5 miles from, basically extends inward or landward 5 miles from that area. From the boundaries of the critical area. So you have the half mile for the critical area, and then beyond that half mile, another 5 miles is protected area. Same with lower Lake Wiley. So you have 1/2 mile inland from Full Pond, and then another 5 miles beyond that, that's within the protected area.
As you develop.
I wouldn't be able to answer that question. I'm not really sure. You'd have to ask somebody in our stormwater section for that information.
Here's where I'm going, John. So the tearing the house down is gonna meet the requirements now.
Mhm.
So Lake Wiley setback is 50 feet from the water. Mountain Island is 100 feet. Mountain Island has CA1, 2, and 4. CA1 is on the water, 2-acre minimum lots, 6% impervious. CA2 is half-acre lots, 24,000 square feet minimum, blah, blah, blah. They're gonna have to meet the impervious requirements. I do not understand what the Lake Wiley watershed impervious requirements are. If they're on the watershed, or I'm sorry, if they're on the waterfront, they should have the strictest watershed requirements or DUA requirements.
So on Lake Wiley, in the Lake Wiley watershed area, within the critical area, so because this would be in the critical area, being within a half mile, for residential development, you're allowed a low density option, which is 24% built upon area, or you can have a high density option, And there's specific standards in Article 23.7 that you have to meet. And with that, then you can do 50% built upon area. So it depends on which density option you're going with as to what built upon area you're allowed. This all would be reviewed, obviously when they come in for a land development permit. And I think, there's considerations that are made for like existing impervious surface coverages and stuff like that. So, they haven't gone through that review yet. They're getting ready to submit their land development plans. So they would be having to take a close look at that and make sure they were compliant with the watershed rules whenever they submit it. But I don't know if they've gotten that far yet with their calculations, but regardless, in order to have an accessory structure in the front, they need a variance from that regulation for accessory structures. So the built upon area for us, staff wise, is kind of irrelevant.
To me, it's the car. Can't do it.
Well, they could potentially make the house smaller because they don't know, like the plans for the house aren't finalized either. So there's wiggle room that they could use to adjust their square footages to get them with compliant.
I think they can build their house. If we approve this variance for the.
It would make it easier for them to build their accessory structure. The house they could build regardless of whether or not they got a variance today or not.
That's a good question.
If you want to speak, we'll have to open the hearing up to you after Ms. Montague finishes her. Okay, so thank you. Okay, go ahead, Crystal.
Thank you for that information, John. Unnecessary hardships does result from the strict application of the regulation because it requires the accessory structures to be located in the side or rear yard. The UDO also requires a 50-foot lake buffer along the shore of Lower Lake Wiley. Due to the proposed home's location on the most level part of the lot, which is towards the rear of the lot, the steep topography sloping down towards the lake and the 50-foot lake buffer, there's not enough space to locate the accessory structure on the side or rear. To meet the location exception for an accessory structure, the proposed home would need to be built at least 150 feet from the right-of-way, which is not possible because of the lake buffer. The hardship does result from conditions that are peculiar to the property because of its topography, lake buffer, and shape of the lot. Also, as shown on the applicant's submitted variance exhibits, the topography is steep, ranging from 600 feet above sea level at the street right-of-way, sloping down to 570 feet, the full pond elevation of the lake. The applicant plans to construct the new home on the most level portion of the lot outside of the lake buffer. The proposed home will be 90 feet from the street right-of-way. The shape of the lot is a unique wedge-shaped tract with a narrower frontage along the Snug Harbor right-of-way that widens out along Lake Wiley. The lake buffer reduces the building area to the north and west of the lot. The hardship does not result from actions taken by the applicant. The site constraints existed prior to the owner purchasing the property in 2014. Per the UDO standards for granting a variance in Article 37.8A13, Roman numeral 3, the act of purchasing property with knowledge that circumstances exist that may justify the granting of a variance shall not be regarded as a self-created hardship. Lastly, the requested variance is consistent with the spirit, purpose, and intent of the regulation, such that public safety and substantial justice is achieved. Placing the accessory structure in the established front setback will avoid impacts to the steep terrain and lake buffer. The physical pavement end of Snug Harbor Road is 154 feet short of the road's right-of-way, while the proposed accessory structure will be 35 feet from the street right-of-way and the home 95 feet from the right-of-way. The accessory structure would be set back approximately 176 from the edge of pavement And the principal dwelling would be set back approximately 250 feet from the edge of pavement for Snug Harbor Road. Several lots included, the subject property have driveways extending from the end of the pavement onto their lots, such that it appear from the paved portion of the road that the dwelling and accessory structure meet the qualifications for the accessory structure location exception. It is not common for properties along the lake to have accessory structures in the established front setback due to topography and lake buffers. Other lots in the neighborhood, including the adjacent property to the north, have similar detached accessory structures in the established front setback. Granting the variance would not adversely affect the adjacent or contiguous properties, and granting the variance would not alter the essential character of the neighborhood. And here's in Exhibit 13 shows the property posted on the sign posted on the property. Excuse me.
I need to make a correction to the percentage statement. I stated.
12%.
Well, for Lower Lake, because I didn't realize this was in Lower Lake Wiley. In Lower Lake Wiley, the maximum percentage for built upon area is for the low density option is 20%. Still 50% for the high density option if you meet the standards of 23.7.
This is in the ETJ.
I would assume so.
I was.
Basically on the edge of the county.
Yeah, matter right. Still gonna follow.
It would still follow our jurisdiction and our rules and, yep.
20%.
Okay, any other questions for staff?
Has what's, would there be the ability for the city to give up its right of way? And give these three landowners the land that they're not using, that the city's not using now? Would that be an alternative?
If this is in the ETJ, that would be a state maintained road and there is right of way abandonment procedures. That I know from the city's right of way abandonment process, that's pretty complicated and time consuming, costly effort. I don't know what it looks like for the state maintained right of way.
Any other questions for staff? Okay. Shall we close the hearing and deliberate, or would you like to hear from, like, I'm assuming the homeowner is here, but we need to move that then to the regular agenda.
I think John's made it pretty clear. I think we're good.
Okay. All right, so we are closing this public part of the hearing and we're going into deliberations. Do I hear questions or comments or a motion to approve?
A motion to.
All right, Ms. Sun has made a motion to approve. Do I hear a second?
Second.
Thank you, Mr. Court. Mr. Williamson,
Williamson, yes.
Mr. Shea,
Say yes.
Ms. Sun, Mr. Court,
Corey, yes.
and Dryden, yes. So variance is approved. All right, finding of facts and conclusions of law. I didn't see any corrections that we needed to make. Do I hear a motion to approve?
Move to approve.
Thank you, Mr. Court. Do I hear a second?
Second.
Ms. Sun, thank you. Mr. Williamson,
Yes.
Mr. Shea,
Say yes.
Ms. Sun, Mr. Court,
Corey, yes.
and Dryden, yes. So the finding of facts and conclusions of law are approved. Thank you. All right, moving on, we are now to variance 2026-0027 for property located at 7611 Beatty's Ford Road.
All right.
All right, Mr. Kinley, you may proceed.
This is a variance from Article 4.3C, Table 4-2. And there's a footnote number 5 under that says that when you have a corner side setback along an arterial, that it is supposed to meet basically the same dimension as your required minimum front setback. So for N1A zoning, the front setback is 27 feet for a principal structure from the main frontage. But if it's normally and then you on a corner, you can reduce that by half to 13.5 feet for a corner side setback. But because the lot is on a corner of an arterial street, then on that arterial street, you have to increase it to 27. So what they're asking for is basically a reduction in that corner side setback to be the same as what it would be if it wasn't on an arterial, essentially. And this is for a parcel located at 7611 Beatty's Ford Road. It's at the corner of Miranda Road, which is the main frontage, as you'll see in the plans. And then Beatty's Ford Road is the corner street, the corner side is where that would apply. So this is the vicinity map, property just south of 45 off of Beatty's Ford Road. And this is the lot in question at the corner of Miranda at the bottom of the page and Beatty's Ford on the right. Oops. Exhibit 3 is the zoning map showing the property is zoned N1A. And Exhibit 4 is the Google Street View of the property. I think this house has since been demolished since this was taken a couple of years ago, I think. This is a variance from Article 4.3C as I stated. Again, that footnote reads, when a corner side setback is located along an arterial street, the corner side setback shall be subject to the minimum front setback dimension for that zoning district. So the minimum front setback for the zoning district is 27 feet. This is on a corner of a arterial, so that was supposed to be 27, and they're requesting 13.5, which is a 13.5 foot decrease. So approved plat, exhibit number 6. This was approved and recorded on September 25th, and it established the 2 lots, lot 1 to the left here, and then subject lot. And the approved plat shows a 13.5 foot setback from the future right-of-way dedication in 2 places. It is labeled here and labeled here, pointing to this corner side setback line here, which was measured from the future right-of-way. So measuring from the future right-of-way is the correct way to do that. The difference is instead of 13.5 feet, that should have been 27 feet. That's what was on the plat that's submitted when they established the 2 separate lots. It wasn't caught whenever the plat was reviewed, and so it got recorded with a 13.5 foot corner side setback. Shortly thereafter, they submitted an LDR. Oh, and that plat was approved in September of 2025. So in October of 2025, they proceeded with thinking that everything was good. They submitted an LDRL, which is basically a land development application for individual residential lot development, along with revisions that occurred in October and then in November, and then more revisions in February and more revisions in March. All of those, over the course of those revisions, they all showed 13.5 foot setback, and ultimately the approved LDRL permits showed a 13.5 foot setback, which, and again, in 2 different places, here and here, labeled, and it was not called. So the LDRL was approved. So now the applicant has submitted a plat to establish a shared driveway between this subject lot and the lot next door, because they're developing that as well. And they're going to have one driveway off of Miranda. I don't think we've got a plan showing that, but essentially this driveway here goes behind the unit here on lot 1 and then ties into Miranda. So they're sharing the same driveway. To establish that shared driveway, they submitted a new plat to establish that, and then also to facilitate the sale of the property to future homeowners. And during that plat's review, staff caught it and noticed the error to the corner side setback. And so that is what preceded them to now request the variance request, because they've gone through all this work to with the assumption that what they originally submitted on their plat in 2025 was correct. And in good faith, based on what had been approved by staff already, have been working with this 13.5 foot setback. So the area of the proposed building that would be encroaching into the required 27 foot is here. So about half of the unit would be within the 27 foot. But again, we're measuring that 13.5 feet from the future right of way. They've dedicated future right of way for the eventual potential widening of Beatty's Ford Road. And that distance is 42 feet from the current center line. So the dwellings on the property have been sized with drainage designed to ensure compliance with the watershed requirements, impervious coverage limitations, and on-site stormwater mitigation. Changes to the project's footprint and roof area and driveway configuration or impervious surface calculations to accommodate the 27-foot corner side setback would likely require redesign of their stormwater approach, the product type, and to accommodate both setback requirements and the stormwater and watershed requirements. So again, with having to basically work with what they were working under the assumption of, rather than having to go back and redo all those other calculations and work. The standards for granting the variance, all four of these have to be met in order to grant the variance, and I'll give you a minute to look over the findings before I jump into those.
John, has anything been built here yet?
It's not been built yet.
I say again, staff. How are we missing these things? Are we not looking at the ordinance? Who's looking at these that's saying, yeah, this is, I mean, in this case, I can't fault the developer because they turned in the plans. And staff continuously for a year approved them. Thank goodness it was caught before they built something again. And we're back to, please give us this feet, 2 feet, 3 feet, 6 feet. What are you guys doing to correct these problems? Can you say to them, who's looking at these?
So we have our individual zoning review staff that are assigned projects based on their area. And they're the ones who review, we have both subdivision staff and we have zoning compliance staff. So both the subdivision staff person that looked at the original plat, made a mistake in not catching it, and the zoning reviewer who reviewed the LDRL didn't notice that there was a discrepancy there. Training, I guess, is really the answer. Working with the staff who are doing those reviews to train them. It's not zoning administration. Our team is, we're not really responsible for that. So there are other folks who would be working on that. So I can't really speak to what all is being done because I'm not familiar with it, everything. But yeah, training would be the best thing that we would have to be able to resolve this in the future.
Definitely recommend to somebody some training in this.
Yeah, I would just say that, I think when you look at it, I can see how it got missed like throughout the revision process. Cause when you look at it, it looks like the front setback is on the side street and the side setback is on the main street. And so I could see how that could go through. It seems like, and when you're doing the plat review, I would imagine like having a plat replatted, like that on a residential on an artery road. It's not exactly, it's kind of like a secondary exception type of thing. So I can see how it slipped by. So I can see how it slipped by the subdivision or the platting portion. That seems like a slip. And then the multiple misses on the review. I don't think there'd be anything red flag wise that would have shown up on it because it looks normal.
It looks, yeah.
Yeah.
Yeah, it's a footnote under so we have our table that shows what the setback dimensions are, and under that table are several footnotes, and this is the 5th footnote under that. So you have to read the fine print in the ordinance as well.
So do you know off the top of your head, something is being commercially built right across Miranda. Do you know off the top of your head what that is?
I don't. I saw that in the street view imagery when I was looking through, deciding what photos to put in the presentation. I don't know what that is, what that building is.
That would have to, if it's, well, this is zoned, I don't know what this is yet.
It's zoned in one. This subject lot is zoned in 1A.
It's N1A.
Yeah, and I'm not sure what the zoning is on the south side of the street.
Take a look here.
We would need to pull up what Mr. Shea has on his iPad so that the entire board.
N1A as well. Okay.
Yeah.
Okay, all right, John, go ahead.
Do we need to pull?
Yes.
pull it up?
No, it's okay.
We do. The board needs to be able to see what Mr. Shea's looking at.
Pull up where?
Can we make a reference that Mr. Shea is looking at Polaris to check the zoning of the property across the street?
All board members need to be able to see what other board members are seeing. Can you please pull that?
I don't have the crystals getting pulled up.
I can pass my iPad.
I think that staff, though, and the applicant would also need to be able to see it as well.
Hamilton. Here's a, you know, how they use. You're a surveyor a little later.
We need a corner lot specialist.
Well,
It needs to have, if you're working on a corner line, stop what you're doing and call John. So make it a whole different.
How many times corner lots come up here? Corner lots come up here all the time,
yeah.
all the time.
It's one of those big systems.
I'm okay. Okay. That's okay. with me.
Yeah.
You can just pass it.
Yeah.
Something went on.
I'll show it around.
Yeah, show them. Show them. So as Crystal will show the board, the property in question is zoned N1A. It is actually owned by the city of Charlotte, so we're building something. I don't know what it is. I'm told it's yeah, fire station.
Please show it to the applicant as well.
And John, did you say that part of this footnote thing is it? It's in anticipation of the widening Bates Ford Road?
So the whole idea behind having a larger setback along arterial streets is because they are larger, busier roads generally. And there's potential for them to be widened because of the amount of traffic and volume that they have. So the ordinance, the purpose, the intent of the footnote is to set aside additional setbacks along those busier roads because, you know, people don't want to live generally right up next to the street or that close to the street, and then just to have the ability to have space for future widening projects. They are dedicating the future right of way in this case, so we feel that there's going to be adequate space to accommodate any future widening that would need to be done outside of the reduction of the setback.
Right.
The ladies
Go
back
ahead.
there to the right, they signed up to speak in opposition, but they didn't write it there. They just told Kanisha right now.
Oh,
So just,
the distance?
yeah.
So apparently we do have folks here in opposition of this case. They, have they signed up yet? Oh, okay. So they signed up for it. We didn't realize that there were people here opposed because I guess they signed up for a different case, but they're here for this one instead. Oh, they're here in opposition of both. Okay. So I guess if we want to move it to the regular agenda and the applicants can speak,
right.
but I need to finish my presentation.
Yeah, well,
first.
so, Mr. Kinley finish his presentation and then we'll move this variance to the regular agenda because there are people in opposition to this. Okay, Mr. Kinley, you can continue.
All right, unnecessary hardship results from the strict application of the regulations. Let me move this out of the way. The configuration of the lot and the required setback locations, the strict stormwater and built upon area regulations restrict development of the site and dictated the site layout and design of the approved land development plans for the project. The lot is located on the corner of an intersection of two streets, Miranda Road and Beatty's Ford Road. And per the UDO, the narrowest frontage of a corner lot is considered the front, and the longer frontage is considered a corner side. Per table 4-2, the corner side setback in N1A is 13.5 feet. However, per footnote 5, when along an arterial, the corner side setback increases to the dimension of the required front setback, which is 27 feet for N1A zoning. Property is located in the western Catawba Critical Watershed Area or overlay in the North Carolina region, in which the UDO requires strict stormwater and built upon area regulations that have to be considered when designing this project. Each unit was specifically engineered and approved to manage its stormwater runoff independently through the use of the dedicated rainwater cistern systems. And each unit was sized and incorporated into approved drainage design to ensure compliance with the watershed requirements, impervious coverage limitations, and on-site stormwater mitigation. And then a rear load permeable paver driveway is incorporated as another critical component of the overall stormwater management strategy to help maintain compliance with the BUA limitations affecting the project. Changes to the project's footprint, roof area, and driveway configuration or impervious calculations to accommodate the required 27-foot corner side setback would likely require a redesign of the stormwater approach and product type to accommodate both the setback requirement and the watershed stormwater requirements. Hardship results from conditions that are peculiar to the property because of its location along an arterial street, combined with the impervious coverage limitations on the site stormwater mitigation standards dictating the location of the structure on the lot. And the hardship does not result from actions taken by the applicant or the property owner. While the original plat submitted by the applicant incorrectly showed the 13.5-foot corner side setback as opposed to the required 27 feet, the plat was approved and the applicant proceeded in good faith, believing that the corner side setback they showed was correct based on the approval of the original plat and subsequent approval of the land development plans. Staff errors alone do not automatically provide the right to receive a variance. However, in this case, substantial reliance on the approved plat and approved plans combined with the strict ordinance requirements for setback, stormwater, and watershed based on the conditions of the property create a hardship. And then the requested variance is consistent with the spirit, purpose, and intent of the regulations such that public safety is secured and substantial justice is achieved. The intent of the water corner side setback for arterials is to allow space between the proposed dwellings and busier roads to provide space for future widening projects. The applicants provided a right-of-way dedication along Beatty's Ford. The requested 13.5-foot corner side setback does not encroach into the future right-of-way and would not prevent the future widening of the right-of-way. There are no driveways off Beatty's Ford Road as the development is rear-loaded and accessed via single shared driveway from Miranda. The project was intentionally designed to align with the character of the existing single-family structures in the neighborhood, unlike 2- or 3-story townhome style units with single-car garages. And exhibit 14 is a photo of the property, and you can say that they have begun grading work, but they
All
haven't
right,
started
so
construction yet.
the driveway, how many buildings are there going to be on this lot?
One building on this lot.
Only one?
Yep.
And one behind it?
There's go back here.
Yeah, that,
So there's two. So
but the driveways are going to be off Miranda, not Beatty's Ford Road.
correct. Yeah, the driveway would come off of Miranda from here and loop around the backside of the two lots to
Okay,
serve the building on this lot and the proposed building on this lot.
okay,
And again, what we're talking about, this lot is the subject property,
right, okay.
the one to the right.
All right, any other questions for staff? All right, moving this to the regular agenda.
I need to make a motion to move it to the regular agenda.
I think you can just take it off.
All right.
Put on the record that it's part of the
All
regular
right.
agenda.
all right, Mr. Court.
Can we also make sure the applicant doesn't have any questions for staff?
Yeah, the applicant needs to come up to the table, please. All right, if you will, put your hand on the Bible, please, and, if you'll state your name and spell it for the court reporter after we swear you in. Do you solemnly swear or affirm that the evidence you shall give to this board and the action shall be the truth, the whole truth, and nothing but the truth, so help you God? If you'll state your name and spell it for the court reporter, please.
Logan, Preach, Preach.
Sarah,
Okay, thank you. All right, you may continue.
If you're gonna, yeah, if you'd like to present, you can actually stand up here. And then this little rolling ball, you can just kind of like back
Okay,
and forth and it'll change the sides.
okay, thank you, Crystal. Okay. So John covered a lot of this information, so we'll just kind of get on to any new or relevant, kind of what we can add value wise. So we are here on behalf of Smith Douglas Home in regards to the property at the intersection of Miranda and Beatty's Ford. As we discussed, this is zoned N1A. That whole area surrounding it is as well. The plat that initially went through September 2025 showed the setback that was approved. John's already kind of outlined our timing as well, but again, that went into October and then again, multiple revisions throughout with city staff review and approval, showing the 13.5 foot setback off of Beatty Ford Road. This is the approved land development plans. This is part of that plan set showing kind of the existing drive off of Beatty's Ford that will be removed. So improving kind of that safety condition from that perspective to install the rear driveway to access off of Miranda Road. I'm sorry, Crystal, is there a pointer or
Right here.
this? Thank you. And so that is showing that access. This isn't labeled, that's the setback
So,
building envelope. Yes,
excuse
ma'am.
me, where's the driveway that's gonna be removed?
This area right here is shown.
And where will the driveway be?
It will come to the rear and then come around on the other plans.
Okay, thank you.
And so and that's part of this kind of the intense watershed. This is a bit impervious paver set is what they've kind of designed it for very intentionally. For the duplex here, again, on this plan set, it's kind of showing those 13.5 setbacks on that site. This is showing that stormwater, very intentional design, how they've come all through with that. I think the products, we're gonna address that as well, going into.
Just want to mention one.
Yeah.
Yeah, this property is utilizing rain cisterns as well for the stormwater runoff, and the equipment has already been ordered and delivered to size appropriately for the runoff from these units as well.
And so this is what John is referencing, right? Here's the table, here's the setback that was used. When you get into kind of that footnote, it goes into the street map, how that's classified, then you have to go back to the UDO to figure out how that classification is then defined for the arterial. And then we get down here to the bottom that you can't even really see for footnote 5, but how that would then subject you from a 13.5 to a 27 foot. There's the variance exhibit showing the significant encroachment as a result of that setback being applied. And so we are requesting a 13.5 foot variance to allow for that. One of the comments that we haven't addressed is this is a single story ranch product. This isn't a 2 or 3 story product with a single car garage. There are 2 car garages as well. And so all of that has been very intentionally designed with the rainwater cistern and other to accommodate kind of a larger ground floor footprint. And part of that was to fit in better with the surrounding existing residences off of Beatty's Ford Road. We've talked about how kind of the critical watershed overlay that applies here and how they have build upon area requirements, and the rainwater cisterns that Logan has already addressed. We do think if they're then forced to accommodate that 27-foot setback, that significantly imposes additional cost to comply with those. The current product could not comply. And so here is an elevation of that product proposed at the site or approved through the approved LDRs. Again, referencing back to just how the cisterns and everything was designed based on roof slope and all the other intentional design elements here. On Beatty's Ford also, and John briefly kind of mentioned this, but so it's a total of 52, almost 53 feet back from where the edge pavement is, once you take in the center line plus the 13.5. Smith Douglas has spoken with NCDOT. They didn't indicate any objection to given their future plans and right of way, given that separation as well. And again, just noting that there is no driveway being proposed here. We're actually taking one away and relocating that.
So we already already have given future right of way to the NCDOT and need for their future widening and over, what was it, 52 feet from center line in the future. So these structures will be well away from, probably even when I'm gone, Beatty's Ford is finally widened.
And so based on those, as we noted, the need for the variance doesn't arise from actions by the owner. It was done in reliance upon staff review and approval of a variety of plans for the development of the property. It's a reasonable accommodation that doesn't infringe or undermine public safety. It doesn't materially detract from the character of the neighborhood and permits product that actually better enhances and works with what is existing in the area. Strict compliance would significantly impact and cause detrimental harm to the impact of the product and cost and compliance. And for that reason, we respectfully request the variance.
Is there a building on there now?
No, we had a building permit in hand and were told that we should hold pending this hearing, but we were ready to pour a foundation.
I mean, was there an older building you took down?
Yes,
You
sir.
did, okay, yeah.
As I was saying, I think it's shown on the initial plans.
But we could have proceeded and ended up here in a situation where it was actually already built legally.
All right, any questions?
And y'all, so I assume y'all own the lot behind this one?
Yes, sir.
And so
Adjacent.
the driveway will go through that lot and then out to Miranda before hitting. So and that is adjacent to the subdivision?
Yes, sir.
Okay.
So this parcel.
Correct.
47 is where the other duplexes will come in as well.
So it'll be a permeable driveway off of Miranda that wraps around. That will be a shared driveway between the units.
Permeable driveway.
Yes. Yeah.
Okay.
Pavers.
So this is a duplex here and then there'll be a duplex on the other
Correct.
end?
1-story product.
Any other questions from the board? Thank you. All right, we have someone in opposition to this.
Yes.
All right, if you'll step forward, please. Thank you very much for your presentation. Ms. Beeson and Mr. Creech.
Good
Oh,
morning.
no, I have to swear you in if you'll step over here, please.
Oh. Here.
Thank you. Put your hand on the Bible.
You
All
have
right.
to turn the microphone on. Ma'am,
Turn
you-
it, push the red,
Yep.
push the button on the microphone. There you go. Thank you. All right. Do you solemnly swear or affirm the evidence you shall give to this board in this action shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, if you'll state your name and spell it for the court reporter, please.
Thelma Byers hyphen Bailey. Thelma, Thelma. Byers hyphen Bailey, Byers, Byers hyphen Bailey.
Okay, thank you very much. Okay. We appreciate you coming today.
Thank you. I'm a resident on Beatty's-Ford Road, not in the specific area of Beatty's-Ford that this residence is proposed for. But I have lived Beatty's-Ford Road and watched the traffic congest. There are times on Beatty's-Ford Road when I leave my house, I have to go out the back of my neighborhood to get on the freeway. I can't even get onto Beatty's-Ford Road because of the traffic. Beatty's-Ford Road is a major thoroughfare from the upper part of the county through Charlotte. And I don't believe and the freeways have not reduced that traffic. In fact, the freeways traffic congestion has enhanced the traffic congestion on Beatty's-Ford Road, and it goes all the way up to the lake. And I have driven that entire part numerous times. And that where it is right now, that's just a 2-lane road back where this particular site is. And the traffic, in order to relieve the congestion that we experience in Mecklenburg County, Beatty's-Ford Road is going to eventually be enlarged, regardless of whether the county or the state think it is. That's the reality that we who live on Beatty's-Ford Road are having to reconcile. And I have a house, I live in a house on Beatty's-Ford, and I live daily watching all this traffic and knowing I'm gonna eventually lose some of my front yard. I don't feel it's appropriate to put somebody else's property so close to Beatty's-Ford that they're gonna have the traffic coming right up next to the only way they're gonna have any privacy is gonna have to put up a privacy wall. And I don't think it's appropriate to do that. I know this is an imposition. I live with it, and with my home sitting there and knowing I'm gonna face some adjustments. It doesn't make sense to put somebody else in the position where they're gonna eventually be so close to that traffic that they're gonna have to make some adjustments. And it would be better to make those adjustments now and abide by the setback that was supposed to have been, rather than to allow this variance and put them in a position where they're going to be that close. I live with that traffic going by my window every morning. I can wake up, that's my alarm clock. So it's traffic. I don't think it's reasonable for us to put them in a position where they're going to have to live with that, when the plans originally stated that there should be more room.
Okay. Well, thank you very much. I appreciate your comments. Where on Beatty's-Ford Road, can you look over your shoulder and tell us where your property is located?
My property is nowhere near that. I live in town at 1800 block of Beatty's-Ford.
Okay.
This is way up the road, but I
Right up
have
the road from that. Okay.
I drive that road to going up to Jeton Park.
Okay.
'Cause
So
I
you're
can't get on-
speaking more to the traffic issues on Beatty's-Ford. Okay. All right.
Yes.
Well, thank you very much. I appreciate you coming in, Miss Thelma.
Thank you for hearing.
All right. All
Mr.
right.
Eden.
Any questions or comments?
Mr. Eden, can we give the applicant an opportunity to respond if any other comments
Applicant, do
they
you have any response you may speak to this if you wish?
I too live on Beatty's Road, and I actually recognize one of my neighbors here present today, which is funny. Good to see you. Yeah, we have already dedicated the necessary right of way for the future improvement of Beatty's-Ford. The NCDOT, we actually have in writing, I wish we would have brought it, have provided no objection to this in the future. So We don't believe there'll be a future taking. There won't be any substantial impact to these residents. And in fact, if we were to defer from the one-story product that we are proposing, we would end up having 2 to 3-story product that would be actually more grossly out of character of the existing area. And then again, trigger a complete redesign of the BUA and permeable calculations, which has been a lot of an undertaking. And that's all I have.
Okay, thank you very much.
What is the BUA for you? It is a lot,
Like less than 17%.
less than 17.
Yeah. It was very significant.
Okay,
Whatever it's in the notes, whatever watershed that we're currently in.
all right. Okay. I don't know if it's
Thank
in
you.
here or not. Thank you, Mr. Creech. All right. If there are no more questions, we're gonna close the public part of this and we will go into deliberations. Comments, recommendations, questions, board.
The owner has a right to develop this lot. He went on the good word of zoning. Staff. I would be in support.
Okay, Mr. Court?
I'm sensitive to the concerns of the, those in opposition. I understand that the proximity to the road is of importance. I respect the evaluation of staff and their recommendation, to, approve the variance. I feel like the, significant work was done by the applicant in order to get to this point, and that similar product and similar impacts to traffic would likely result just in a different configuration, but a significant more cost to the property owner if it were denied. So the overall impact to the for those who are in opposition probably wouldn't change. It would, the only thing that would change would be the hardship to the property owner. So I think I would be in favor of supporting the variance.
Okay, thank you very much, Mr. Court. Any other comments, Mr. Williamson or Ms. Sun?
I agree with the other board members.
Okay. All right, then do I hear a motion to approve?
Move to approve.
Thank you, Mr. Court. Do I hear a second?
Shea.
Okay. Mr. Shea and Ms. Sun, second. All right, Mr. Williamson,
Williamson, yes.
Mr. Shea,
Shea, yes.
Ms. Sun, Mr. Court,
Court, yes.
and Dryden, yes. So the variance is approved. I don't see any corrections that we,
Make a motion to approve it as is.
thank you, Mr. Shea. Do I hear a second? Thank you, Ms. Sun. Okay, Mr. Court,
Court, yes.
Ms. Sun, Mr. Shea,
Shea, yes.
Mr. Williamson,
Williamson, yes.
Dryden, yes. And so the finding of facts and conclusions of law are approved as written. At this time, the board, we're going to take a 10-minute break, please. We'll see you back in 10 minutes.
Yeah. Agenda. Yeah.
Surprise.
No surprise.
So you can come down to your place.
Yeah.
What you think about that?
Huh?
What you think about that?
Yeah, I'd love to show you the plans.
Never know.
Yeah.
To get,
Yeah.
hey,
Yeah.
if you got.
I can
Buy you lunch.
ideas.
Finish right here. And then if you're able to go back to the picture of the ways the cars are, you're like, there's just, they would have to drive in, down, and then park 1, 2, 3, 4. And then where does the parking go for that ADU in the back? Is the question that I have.
Yeah, that is a good question for staff. Like, so 1.5 for a duplex. You got two units, but you got a third unit with the ADU that adds up to 4.5. Is the ADU required any parking?
ADUs do not have a minimum parking requirement.
Gotcha.
And as far as the on-street parking, so you can park on-street on a local neighborhood street. But there are rules like, you can't park within a certain distance of a intersection because of site triangle limitations. But all that is enforced through CMPD. So if there's people who are doing illegal parking or blocking a street or something like that, it could be reported to CMPD. They would come out and cite them for illegal parking. But generally speaking, you can park on street. You just can't use that on-street parking to meet your minimum parking requirement. So the minimum parking requirement has to be met on the property that's being developed.
And this, I mean, this is further complicated by the fact that that house hardly has any street frontage. So there's not really any street for them to like dedicated to them in front of them, because it pretty much stops right before their property, doesn't it?
It does end like basically right in front of the single family house. So there'll be a driveway that kind of comes off at an angle at the end of the right of way or the end of the street, what's paved currently.
Why isn't that street finished? Like, why is it?
Because of the creek that's at the bottom. So
Well, yeah, there's creeks everywhere in town.
I guess whenever they were building these streets, they decided that was too much of a obstacle to cross. And so it's not just this block. There's multiple streets in this kind of neighborhood that all stop short of this tributary.
We had streets like that in our neighborhood that were not originally platted and not originally developed, but eventually over time they became developed. Do you think that the developer developed those, or like?
It depends on the situation. If it was, something where we saw it from a overall connectivity in the city, then it could have been a city project to try to complete that connectivity. In this case, they are, they're platted right of way. So they've been in existence since, all these lots were created. It's just, they were never built. And it can occur that, over time as developers develop, then those streets are improved. The challenges are, with it being in the floodplain and, or potentially in stormwater, construction buffers and that kind of thing, then it's just additional cost. And so developers generally try to avoid having to develop property where they would have to extend or and the improvements to the right of way itself. And so CDOT does allow folks to pull driveways off of the ends of where the maintenance ends, have a driveway pulled off of that without having to further extend the improvements to the road. But obviously to get to the next lots over, you would have to do something to the end of that to extend it further to be able to provide access.
So looking at this picture where the car is parked at the far end there, that's approximately where the driveway would be for this new duplex.
Hard to tell from the angle of this photo, but I would say roughly somewhere in that area is where the driveway would be coming into that lot at.
So it would come in.
If you go back to the site plan, it shows kind of the angle at which the driveway will be coming down from the street. So in that left-hand image there, this exhibit 6 site plan, it shows that angle of a driveway coming into the property.
It kind of feels like it would make it awkward for the person on this side to get into their part of the duplex if there was actually somebody parked in the other side as well.
The developer extend the road to the end of its lot to create a little more space for everybody?
Yeah, I mean, it seems like developers are asked to create offsite improvements from time to time for projects on adjacent street right of ways. How is this dealt with? I mean, how is this being dealt with across the city for unfinished streets? Are there neighborhoods that are prioritized? Does CDOT have a list of, okay, we didn't build this street here, we're gonna have to build it. I mean, it's clear if you go to the neighborhood map of this, that this is an intended street to connect over at some point. Do you have a overall street grid view? Where you can, it was in the presentation
Yeah,
earlier.
on the tax map.
I mean, I agree, we're not really looking for a parking variance we're not discussing a parking variance, but parking was used as a
Reason to.
reason
use it.
for needing this variance. And so, you know, I feel like we need to look at this. So an overall neighborhood view. Yeah, I don't know where it was, but
Well, on the tax map, you see where the road ends. If you zoom out on the Polaris, you could see that.
there you go.
And if you go to the street, if you, instead of hybrid down in the bottom right corner, if you click on the street view,
You'll see the
yeah,
connection. Back of it.
yeah.
About 400 feet.
Right. So there's a Blue Line Creek on St. Paul, and then a non-blue line ditch on St. John, and a non-blue line ditch on St. Mark.
How about this, guys? If we. I think the parking is a legitimate concern. How about if we suggest that Mr. Stark add an additional parking spot in his driveway? So the front of the driveway, he's got a turnaround right now. If you go back to the site plan, he's got a driveway coming off of St. John's, and then he's got a turnaround for people backing out of the driveway right there. That's it.
Yes.
That's 20, let's call it, I don't know what that is, but let's say it's 20 feet deep. If he made it 30 feet deep, he would have enough parking for at least one, maybe two cars. I think that would lessen the demand for parking on the street.
Does that
See
bump
what I'm
into the-
saying?
Does that park in that the
So-
front yard buffer?
So you can't park in the required front setback. This is N1C zoning, is that correct? So your front setback is minimum required front setback is 17 feet in N1C zoning. So they have to have 17 feet back from that, and then they've got 16 currently from the area that's like, looks like driveway pad between the front of the building and the area that's gray in that left-hand image, that's 16 feet.
And you cannot park there.
Correct. You can't park in the required front setback. You can park in the established front setback.
So but what happens if he goes left with that driveway?
There may be enough space there. He's getting close to the sewer, because there's sewer easement and the post-construction buffer pinch in right there. It's hard to see, but that right where the laser pointer is,
Yeah.
it pinches down a little bit. So I don't know how much room he has to work with, but that was something that he would have to evaluate on his plans to see if they can make the additional space work. You would have to ask Mr. Stark if that would be something that they could potentially fit in.
I wouldn't be opposed to putting a demand on them to have one more parking spot on site. If everybody wants to.
Do the ADU.
Yeah, where is the ADU?
I can see it right there.
Oh, yeah, there it is. How do you get to it?
Walk. Park and walk.
See.
Ride your bike.
Well, I don't know. I feel like we're trying to jump through a whole bunch of hoops because the developer wants to put a duplex on this lot that is really not the size. I mean, I know it fits the exact, but the developer wanting to maximize the use of this lot. And we're jumping through all these hoops and talking about parking spaces because he wants to put a duplex there. And he's asking us to change and allow him from 20 feet to, I mean, he's asking for height because he needs places to park. when there's not going to be enough places to park if he's got an ADU, even though the ADU doesn't require a parking space. If somebody's living back there, legitimately, they're going to have a car, I would think. And so we're saying, well, let's see if we can carve out another so many feet to get, when he could just build a single family house on this and we wouldn't even be having this discussion.
Well, I strongly support the duplex. We need the density. The UDO is created very much because of the density requirements of the city. So I would not agree with that argument.
I think that this is more deliberation. I think there are some other folks that want to speak. We
Can I also add just one more point that I brought up? It, like in all the other ones that we've been sitting here, it says it fits with the aesthetic
Character.
of the neighborhood. And I think this would severely be different from the aesthetic of the neighborhood. Even the duplexes that are in the Lincoln Heights neighborhood do not sit on stilts with parking underneath. So just another point to bring up. We could.
All right. Anything else, Miss Monroe or Miss
Richard Town.
Terry.
Okay,
Danielle.
Thank you.
Danielle, thank you very much. I appreciate it. All right, someone else is here to speak. Okay. Okay, one of you's been sworn in. We'll have the other lady sworn in, please. Okay, ma'am, do you solemnly swear or affirm that the evidence you shall give to this board on this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Firm.
Okay, would you please spell your name for the court reporter?
Sandra White, Sandra Goins White, Sandra Sandra Goins, Goines, White, White.
And our other person is Miss Thelma Myers Bailey. Okay. Okay, ladies.
I received a letter from board recently, and I just read the first paragraph. It says, "This notice is to inform you that your own property located within 300 feet of a site subject to an upcoming evidentiary hearing held by the Board of Adjustment on the following case," and that's the case we're talking about now. My property address is 1928 St. Paul Street, which is the street going north before St. John Street. So from what this is saying, my property is backing up to the property of 1927 St. John Street. I want to know, is this really the correct information? I saw you had a slide up and it had St. John and St. Paul. It showed the two. Now that's St. Paul, St. Mark up there. Go down. Yeah. Okay, there's St. Paul. That's the property in question in the green. That's my property that has the little line coming through, because that's where a creek or something is running under my property. So it actually does back up. I wanted to know, first of all, if that was correct, that I was giving the correct information. Now, what I don't understand from what I have heard here today and seen, I don't see how the pictures that were shown of the site of St. John Street, how those pictures were backing up the property of St. John. Okay, right there. I might be not correct, but is that okay? On the opposite side, go over. Oh yeah, on that part there.
Okay, give me a second. Does that look familiar? That's across. I'll go up a little bit more.
She's the next street down.
Yeah, that's St. John.
They're still in St. John's.
Your property, yeah.
Yeah. Exactly.
Where's the thing?
Are you able to get St. Paul?
Yeah. Trying. What was the address again? You said 19
1928.
St. Paul.
Is there a picture? Because
She's got the same issue. Yeah.
okay, yeah.
Oh yeah, sorry, it's a little finicky. I'll get the little guy back over there. Okay. All right.
Okay, that's right across the street from my property. That's like 19, what did you say, 30 something?
33.
But if you could zoom across the street from that. All right, I'm somewhere right now. Right there, I think, somewhere a little further down.
Yeah.
Right in there. Right in there, so. Now, the property in question, you supposed to be backed up to my property?
Yes, ma'am, yeah. On the north side.
But I thought when they were showing what you were talking about, you were on the opposite side of St. Paul, not on my side.
Yeah,
It's
they're
backing
backing
up
up.
to me.
You back up to them.
Okay.
And but Crystal, that's a good example of extending the road. You can see the developer, whoever built those two buildings,
Yeah,
extended the road to create the driveway at the end of that street.
So now, the side wall height is gonna be like, 10 more feet, is that right? What you said?
yes. Yeah, I think it's obvious. Yeah, well, but I'll leave that for deliberations.
I just wanted to know if this was correct information, okay, so I got that part. But I'm concerned because, the area now, you're gonna have the duplexes put in there. And this, I guess, is more like a personal thing and that may not fly here, but I've lived in that neighborhood, this neighborhood all my life. I was born in this neighborhood. So I have generations of family being in this gym. And it seems as though there is just this move now to take out family units, just single family homes now. They're coming, you're coming in with, these I call them still multi-dwellings, when you got more than one family under a complete roof. And this is, if you want to, have a single dwelling home there, you're not, it seems like you're being crowded out. And that disturbs me. It really does disturb me, because I think in my community, we are being hit harder than anybody else right now. I have other property that's in another part of that area. And the same thing is seeming like that it's being targeted right now. And it's not a concern about trying to keep anything. I'm in a historic area where I live now, which is, and they're trying to come through and do the same thing. It's just like, there's no sense of, it's family anymore. Anybody being cared that that's some kind of way that we can keep a little bit of it. It's just being taken over. And I'm concerned about that, because I personally know I wouldn't want that dwelling I'm just being serious, a duplex.
I have a question about this picture. This property is located on St. John there. So her property is,
I'm on St. Paul.
oh, there, okay. See that, yeah,
Green spot, that's St. John.
that's St. John's, okay.
Yeah.
And
Is there
you,
a house on your site?
No, but see, that was something on my, okay, the next generation after my children, my grandchildren, we were thinking about that for them to have, to be able to have a home put there, but
Mhm.
Hard to do.
yeah, it would be hard to do. Okay.
I would like to continue this conversation. I'm Thelma Barsfield. I'm president of the Lincoln Heights Neighborhood Association. And so we're seeing this kind of thing infiltrate our community all over. When we were growing up, those St. Paul and St. John and St. Mark were continuous streets all the way down the hill and back upside the other hill. And we used to ride our bikes down through that area. Those, as construction came along, those access through have been terminated. So if you want to go to the upper part of St. John, you have to go around St. Paul and come back through. And I live on St. Paul and get to the other side of St. John and St. Paul and St. Luke, no, to St. Mark. And we've got all kinds of stuff going in there, but most of it is single family. We're having some multiple family duplexes and other things cropping up in other areas of the neighborhood that are not so topographically challenged as this particular area, the Four Saints. All of those streets, all four of them go down and then come back up the other side.
Excuse me, you said they were previously connected, those roads were completed? Okay.
When we were growing up, those streets were connected. I'm not gonna tell you what we used them for, but the bicycle club, that was the test. But extending the upper level on this property impedes what her children will be able to, and her grandchildren will be able to build on the next property behind that. And that extended elevation is it on the picture, it's lower than the house adjacent to it on St. John. But we don't know, what that elevation is going to do to the property that her family wants to build in the future on St. Paul.
All right, any other questions for our speakers? Thank you, ladies. We appreciate you sharing today.
Thank you.
Anything else? Okay.
I think we have additional speakers.
And we have another speaker?
Yep.
Okay. You'll step up, please. All right. Thank you, sir. All right, do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may state your name for the court reporter, please.
Gary Young, GaryYoung, and duly state that I am recusing myself from any delegations or responsibilities with this board for today. Very familiar with this area of land. This is the district that I ran for city council for in 2023. This is an area that I was in just last night at a friend's house. The assessment that you made, Chair Dryden, I fully agree with. Mr. Shea, you are more than knowledgeable about these things, but I have to disagree about your notion. When we talk about the UDO, one of the things it states is, yes, the character and makeup of a neighborhood heavily impact development under the Charlotte Unified Development Ordinance. And these women made the argument. This disrupts the character of this neighborhood to allow this. If there is another structure that can actually fit the conditions of this property, that's what should be saw fit, not to makeshift something that you just see fit or that you want to impose on this community. I know the east side of Charlotte very well. And I know that there are certain things that the east side does not want in their backyard. Why should the west side have a different story? Why should a historically black neighborhood be imposed with things that does not fit the character or the makeup of it traditionally? To your point, Mr. Shea, this UDO allows for more density. I think that was more so for the newer developments, my neighborhood, our area in the Mountain Island section, more so than communities that were built light years before I was even thought of, light years before I was born at Presbyterian Hospital. So the fact that this was under a certain section of the agenda where this has already been not necessarily pre-approved, but it's recommended, I find that disturbing, and I find it even more disturbing if the board sees fit to go through with this. This does not fit this neighborhood. And I question why we continue to see these types of developments change the makeup and character of neighborhoods across this side of town. But when things are trying to change on other sides, there's so much objectivity with it. I'm all for development. I think development is what's going to spur this city into the future. We want more all-star games. We want the McDonald's. I was talking to somebody this morning. We want the McDonald's all-star game in 2028. And so there are certain things transportation-wise, there are certain enhancements we need, infrastructure, but this is not it. This is not what the UDO intended to allow to happen to our neighborhoods across this great city of Charlotte, North Carolina. But we appreciate your time.
Yeah,
Thank you.
just so we're on the same page, my due respect to you, you have been on the board and have seen triplexes built in Myers Park where the neighbors were not happy about it, had the exact same argument you just made, but they were approved. And those neighborhoods are just as old as these Lincoln Heights neighborhoods. And again, they had the opposition, as you mentioned, but they were part of the UDO plan for that density. And that's just the realistic part of what's happening right now with the growth of this city. So I don't think it has to do whether it's Lincoln Heights or Myers Park or Eastover. I don't think the makeup of the neighborhood is part of the case here. I think the issue is, does the UDO allow this for a specific reason? And it does. I'm with you on the character. I don't think that Deborah and I agree on this, but I do believe the density is an aim of the UDO for a very specific reason. And it's something that I would support going forward, again, with all due respect to what you mentioned.
Well, Mr. J, you're always impartial. You're always impartial. You serve from a knowledge-based standpoint, so I respect that fully. And I'm not gonna go back and forth because you are accurate. You are correct on your notion and what you stated. Just being very, very familiar with this neighborhood and this area, I just see the discrepancy between the allotment of the developments of this sort widely varied to those certain sides. But no, everything you stated serves correctly. You are right.
Okay, thank you, Mr. Young. Okay, let me clarify something before we go into deliberation so everybody hears this correctly. Our charge is to either approve or not approve this variance request to increase the maximum required sidewall height of a duplex from 20 feet to 30.5 feet. Now, I need everybody to take a step back and look at what we are charged with doing. And I've made some comments about duplexes, and Mr. Shea has made comments about duplexes. The only point I was making was that had the developer chosen to do a single family house on this lot, we would probably not be here today asking for a maximum height requirement because there would be enough land to put a garage and driveway and all of that. However, the developer has chosen to, and by right, it's, I mean, his right to put a duplex there. Now, part of the problem with the duplex is the underground parking. So as we go into deliberations, board, I would like us to bear in mind what our charge is for this particular variance. And I don't want to get into an argument about whether it should be what the neighborhood is. I don't know if there's other duplexes in this area. I do know that there is a single family home next door to this. I am concerned about where the driveway is and in relation to the underground parking. I don't know if that fits in with what our 4 charges are to look at this, but let's go back and remember that we have to approve or deny this variance based on some very specific requirements. And those are unnecessary hardship, or the hardship results from conditions that are peculiar to the property. That hardship was not something that was taken up by the applicant, because you can't say they don't have a right to put a duplex there. That the requested variance is consistent with the spirit and purpose of or intent of the regulations. So as we begin to talk about this, let's keep those 4 standards in mind and remember what our purview is here with this requirement.
Ms. Dryden?
Yes.
First of all, I agree with you. Thank you. The board does need to base its decision on the criteria. One thing before we move on, the applicant is usually afforded an opportunity to provide anything else they want to provide after the speakers. So I just want to see.
Yes. Okay. If they have any, developers, you have anything else you'd like to submit or say?
If we could have them walk back up to the front, yes.
Yeah, just walk right to the front. You're welcome to rebut anything that's been said. You might respond to some of the concerns that have already been mentioned. Or not.
Just the presentation.
Here we are. Maybe you can just
Great.
scroll.
Thanks for, it's something.
Soon as,
Can I zoom in somehow?
Yeah.
Can I zoom in somehow?
there we go. I know. You touched my shoulder and you think it was in an ice cube. I know.
It's just a dope. It's a control.
She's throws them right under the vents. I'll say this, okay.
All right, just want to make a couple points of clarification. So, ma'am, Ms. Goin, this is the property we're talking about, and this is your property, as you mentioned.
Sir, I'm sorry, could you use the microphone?
Use the letter, yeah.
This one? Okay.
Yes.
Okay, yeah, it's green, yeah.
If you could carry it with you to the.
That
screen,
one
sure.
on the table you can carry, yeah, that's fine.
Sure. So this is the property we're talking about, and this is your property here. There is a creek that runs through it, and then there's also a sewer easement. So this whole half of your property is never going to be buildable, just so you know. And the duplex we're talking about with the height is up here, and then your property is down here, and you only ever could really build on this part of your property just based on the sewer and the PC buffer. So that's just a point of clarification. This is the extra tall part, and that's the part of your property you could build on. These streets do not continue through. I'm not aware of the history, but when I was looking at this property and this one next door, I was talking to Miss Diane, who lives here, and she had told me that one of the things I was looking at was extending the streets, and they said that the residents didn't want them extended, and that was a big part of the reason why they hadn't been extended. But okay, so that was that point. In terms of the, is it Control 0? Control, I guess, scroll. This, what you're seeing is the outline of existing asphalt pavement based on a survey we had done. So it is tight, but there is technically existing access based on the roads that are there right now. Let me think of what else to talk about. Just to be, oh, so in terms of parking, our intention was to provide plenty of parking, and I guess I misinterpreted it. I was thinking it was 1.5 parking spaces per duplex unit, which would be 3 total, and I was providing 1 for the ADU. So in my mind, we were providing ample parking, and that was the intent. Having said that, we would be happy to consider having extra parking as a stipulation. Just knowing that we are really limited to moving the building down because the foundation interferes with the sewer easement. So if we could somehow have a solution where there could be parking in the front driveway somehow, we would be happy to accommodate that. It's just not really allowed in the language as John mentioned with you can't park in the front setback. And then just to clarify, the parking spaces are not below ground, they're at grade, the first floor. Anything else missed?
But according to your own statement, there's not enough parking, even though the ADU does not require a parking, but there is, if someone lives in that ADA, there's no place for them to park based on the requirements for the duplexes.
No, the duplex requires 3 total parking spaces, and we're showing 4, which is the 3 required for the duplex plus 1 for the ADU. So our intent was to have enough parking to be from the start for the duplex and the ADU.
Are you gonna okay, that may be your intent, but what if your takes up each of the duplexes takes up both parking spaces? Then what do we do?
Well, I think that would be a question for property management and how we would enforce landlord policies. I mean, I think that's a separate issue of, are people gonna park in the places they're supposed to park?
So these are gonna be rental units?
That would be the idea, yes.
All right. Anything else that you like to say?
I don't.
No, not at all.
No,
I
that's
think as mentioned, this is a closing comment. Definitely very much hear the concerns of our neighbors. It just came down to, the sidewall height and the fact that we triggered parking questions. I think that's an ongoing conversation, so we're happy to accommodate any, comments you guys have in that regard as a staff. So thank you.
Thank you. All right, ma'am, did you have a comment that you would like to make before we come to? It's okay.
If you could.
And maybe this is just questioning the regulations, if someone can educate me. If it's 1.5 per unit, you would have, each unit would have a half a parking space for like what, a bicycle or something? Half a car,
Yeah.
and then they both back in and like.
That's pretty much
and-
what it is. Yeah.
But so then you'd have 1.5, and then again, the ADU that's in the back that actually encroaches on potentially on your property. I don't understand where does that person park? So I understand the UDO wanting to create more density. I understand now that it's going to be rental units. So someone will likely rent or Airbnb the ADU in the back. The bus line does not come down St. John or Haynes Street, so it would come 2 streets over. So how does someone realistically get down St. John, if it doesn't connect to Beatty's Ford, to the back, to that ADU and not have a parking space? They're going to have to park on the street. So then we're going to have to constantly be calling the police because they can't park on the street. Because as you can see from the pictures, there's actually no space in front of that house to park on the street. So again, I know this is not a parking issue. It's the height of the wall, but the height of the wall is caused because of a parking issue. So therefore, I do think parking does need to be considered into account. And again, I know that there's the 4 areas, but the likelihood of this fits with the neighboring neighborhood, we have had plenty of testimony today that it does not. So just want you to keep that into perspective.
Can you say your name again for the record?
Janelle Monroe.
Thank you.
Okay, thank you, Ms. Monroe. All right, does anyone else have a comment from the general public that they would like to make before we go into deliberations? I want to give everybody an opportunity to have everything they need to say, come say it. All right, hearing none. All right,
Can we close the hearing? Close the
we're going to
hearing.
close the hearing and go into deliberations, but we are going to take a quick 5-minute break before we do the deliberation. So board, think of what you're going to say as we begin again. the request for an increase in the height requirement. We put these variances in place to for duplexes for a reason. And for us to, I mean, they're asking for over 10 feet of an increase. And I just feel like that's too high. That's my opinion. Any other comments from the board?
So the staff is in support of this variance. I think this is a kind of a unfortunate particular condition, and it's a condition that I see around the city in certain areas. And I think it's one of those conditions where it starts to feel really crowded and out of character with the neighborhood. Because the infrastructure is just not there to support the density that the city kind of envisions. So I think when the UDO was enacted, I think the thought was that our city's infrastructure could handle it. But there are areas where investment hasn't been made in the street frontage here. Obviously, there was probably a wooden bridge that was over this creek at some point and a dirt road, and maybe it was a paved road. But when it came time to build it to DOT standards or city standards, the investment wasn't made here. Curb and gutter wasn't made here, and it created some cul-de-sac roads, which is really nice. And it's also sort of a cake and eat it too type of thing. So there are areas in my neighborhood where there's no curb and gutter, there's no sidewalk, but people really don't want to give up their front yard. So they're not asking the city to invest in that sidewalk and put that sidewalk in. And these dead end roads, people, would probably like to have the infrastructure for a dead end road, a proper dead end road, but that requires a bulb out at the very end of the cul-de-sac. Somebody's got to give up property and you got to make that investment in that, or you've got to build the street through. So the neighborhood probably doesn't want the through traffic. So they aren't necessarily advocating to have that road built all the way through. So, I don't know that I would put the blame solely on the city for not having completed this road, completed this investment. I'm trying to narrow my thoughts to the wall, but I feel like character of the neighborhood and some of these parking and infrastructure issues kind of play into why they've gotten into this wall situation to begin with. I think that it would be the neighborly thing to do to extend the street in the similar way that they've done for single family houses that are have a significantly lower level of investment. I would assume that it is these single family homeowners that have created that extra space either before they moved in or after they moved in, after the police got called enough times on them that they realized that they really needed to add that on-street parking for themselves. So I think it would be good to impose a requirement on a developer to do that. But I think that's kind of an overreach for the issue that we're looking at. We're looking at the variance of whether the variance for the sidewall condition is appropriate or not. So I'm inclined to limit my analysis to just that sidewall. I feel like due to the topography, the aesthetic character is not really going to be compromised. I feel like it will fit in aesthetically to this specific condition. I'm kind of siding on the side of staff and their recommendation. I do feel like there's a lot of shortfalls with the infrastructure, with the parking. But I think those are things that the developer could address if they wanted to be good neighbors. So I'll probably be supporting the variance.
John, can you put up the slide with the criteria? I think it would be great for the board to run through each one. And any facts you feel support each one.
So for the strict application of the regulation, I feel like a hardship would result. They would be limited in some of the right.
I've got one.
In how they're able to use the property. I think that the topography and the sewer right of way and the floodplain speaks to the peculiarities of the property. That this hardship is not the result of the applicant. And I spoke a little bit earlier about the spirit and purpose and intent being substantially achieved there. So.
Okay, I think 10 feet of a variance is too much for something that was originally set to be 20 feet, the sidewall height. And I'm pretty familiar with this neighborhood, and I understand parking is a constraint with the duplex and then ADU, that's gonna be a rental unit. There's just not enough space, unfortunately, to park everything there, and there's a very high likelihood of overflow. And so the decision is based on unnecessary hardship would not result from the strict application of the regulation, because there are other ways that the developer can do to still build on the unit and create value. And hardship does not result from the condition peculiar to the property. Because they can still build a single family on it, and hardship does result from the action taken by the applicant because of the way it was designed, and plus the ADU. And the requested variance is not consistent with the spirit, purpose, and intent of the regulation, and safety and character of the neighborhood.
Thank you, Ms. Sun. Mr.
I
Williamson?
agree with Ms. Sun. I think that the rules exist as a whole, and we're trying to pick apart various rules to, make way for a development of something that doesn't fit. And I would be inclined to deny the variance.
Mr. Shea?
Yeah, I think I voiced my opinion before about where I stand, but the fourth point here, the intent of the regulation such that public safety is secured gives me pause. Because it's exactly what the neighbors are raising, right? It's a narrow street, parking's not good. Anything we do to add a public safety issue to that street is a negative. And does this board have the ability to do something about it? I think we do. So I'm with Hamilton in the fact that I think staff is correct. You've got an unusual lot. It's restricted in many areas. It needs to be, we need to give it some give because of that. But I'm also with Marshall and Amy. And I think there are other ways around this that would make sense too. So, I'm surrounded by smart people and I like to listen to them. They make a lot of sense. That's where I'm at.
Excuse me. As Ms. Sun pointed out, excuse me, It says an unnecessary hardship will result from the strict application of the regulation. I don't know that it's necessarily an unnecessary hardship. Because the property can be used. Just not for a duplex. That requires a 10-foot increase in its sidewall to accommodate parking. Because there's no parking on the street. The lot's not big enough for parking unless you put it underneath. I agree that there is some negativity to the piece of property. But it's not, it doesn't diminish the ability to build on the property. It just diminishes their ability to build a duplex on the property. The hardship does result from actions taken by the applicant because that it's self-created. They want to put a duplex here. They want to put an ADU here. And to do that, they want to put under the house parking that requires a 10-foot sidewalk increase. And I agree with, we talked about the spirit and purpose and public safety is secured and justice is achieved. And I think we do have to take into consideration those elements of safety and how are we going to accommodate all these people that are going to live or rent this property. So with that in mind, I'm inclined to not approve this variance request. Any other discussion? Do I hear a motion?
We want to end deliberations first or?
Yeah, deliberations. Yeah, we'll close go ahead.
No, I'm just moving on.
Okay,
That's a motion to deny.
all right. Ms. Sun has made a motion to deny.
Williamson second.
All right. Mr. Court, on the motion to deny.
I vote no on the motion to deny.
Ms. Sun,
Son, yes to the motion to deny.
Mr. Williamson,
Williamson, yes.
Mr. Shea?
McShay.
No, not McShay, Mr. Shea.
Shay, no.
And Dryden votes yes to deny. So it's a 3-2 vote. The motion is denied. To approve this variance to increase the maximum required sidewall height from 20 feet to 30.5.
The motion is approved, the variance is denied.
Right. The motion is approved. The variance is denied, correct?
Yes, there was a motion to deny.
Uh-huh.
So the motion to deny passes.
Passes. All right. Thank you all for participating in that. Okay. So we have to rework these finding of facts and conclusions of law.
Chairman?
Mr. Kinley, or you have suggestions about that? Okay.
I do. Number 6, the applicant mentioned that it was not 32, that it was 30 feet,
30.5.
Yeah,
30.5.
Yeah.
right.
34.
If you're rounding, it's go 31.
Yeah, I've done the rounding rule, but
John made the rounding error up he made it up this morning, so I'm just I'm following what he said.
The 30.5 would round up to 31, so technically it would be, I guess if we're calling out 30.5, then you might as well say it's a 10.5 foot increase. And we'll just roll with the rounding as it states.
So
as
you
it's
say
stated
it,
in-
so you're gonna say a 10.5 foot increase or, oh,
Correct.
okay.
Yeah, so 6 would read, applicant is requesting a variance from Article 4.3D1 to increase the maximum required sidewall height from 20 feet to 30.5 feet, a 10.5 foot increase.
Okay, all right. Okay.
Okay, that was one of them. And well, at the top of in bold, it says staff recommends, and it has the staff recommends approval of the requested variance. That condition, we wanted to add a sentence at the very end of that, which is consistent with number 22 and number 5 of the conclusions of law. That sentence says there may be a fire demising wall between the parking areas
Yeah.
for the units.
But that,
They're adding this sentence to that.
But it's a moot point.
yeah,
Yeah,
it's
it's
moot
fine.
because the variance is
Strike the
denied.
whole-
That whole section comes out. So
Oh.
if you're modifying our findings of fact documents, then you'd want to strike number 22
Right, we're striking number 22.
and number 5 under conclusions of law.
And
I
number
think
5.
just as an option for the board, it might make sense to defer the findings of fact to the next meeting.
Okay,
Draft proposed findings of fact, provide them to the applicant for discussion.
Love that idea.
thank you, thank you.
And also, I'd like to, so the whole request is based upon 32 feet, a 12-foot increase. So we're talking about findings of fact and conclusions of law. Do we need to discuss whether the request is inaccurate? I mean, does that need to be resolved before we leave?
In terms of the height,
Yeah, they see.
it sounded like to me.
I don't think it matters because we
Right,
denied
It
whatever.
doesn't, it matters like today, but
Right, because there was not,
lawsuits down the road doesn't matter.
I don't think, I don't think so, based
Okay.
on the deliberation. I think the decision was there was not an unnecessary hardship, that the hardship was self-created.
Okay, so as chair, I request that we defer voting on the finding of facts and conclusions of law until staff and the applicant have had an opportunity to update and change based on our denial of this variance.
I think we just need a consensus of the board on that.
Okay, so is the board, Mr. Williams, is that okay with you?
Do I need to make a motion to approve that?
Do we need?
That might be better. Motion to defer the findings. of
Motion to defer the findings and facts?
Yes.
Shay second.
Okay. Motion to defer. Okay, well, Williamson.
Do I need to vote against that?
Okay. No, I don't think you need it. Mr. Ford,
I vote yes to defer.
right, Ms. Sun, Mr. Shea,
Shay, yes.
Mr. Williamson,
Williamson, yes.
and Dryden, yes. So we have made a motion to defer and it's passed to the finding of facts and conclusions of law until the July meeting.
Okay.
Okay. Good job.
Good idea, Paige.
Thank you. All right, now moving on to variances. All right, variance number 2026-00019 for property located at 1218 East Boulevard. I know they're not happy with us, but yeah.
They're happy with me. They're not happy with you.
I'm leaving.
Yeah.
They're gonna be you the
Your
property.
town.
How you?
Sorry.
And we do have speakers in favor and in opposition present for this case as well.
Okay,
And correction from what you see on the screen, when we were drafting up our findings of facts, so it's at Abraham Khalil, spelled Khalil of 650 Investments LLC, and they are represented by Jamal Smith of Architect Builder Group. So rather than Architect Builder Group being the applicant, the Architect Builder Group is the agent or the, for the applicant. And the applicant is Abraham Khalil of 650 Investments. So we just got that backwards. And it's for a property located at 1218 East Boulevard. And then the property is owned by 650 Investments LLC and Equity Trust Company. And the request is a variance from Article 20.9 to waive the required landscape yard. Exhibit 1 is a vicinity map of the property showing where it's located off of East Boulevard, west of Kenilworth Avenue, east of South Boulevard, kind of in the middle of the Dilworth commercial area on East Boulevard. Exhibit number 2 is an aerial map of the property showing the existing structure and driveway coming in off of East Boulevard to the, if you're facing the structure, the driveway would be to your right, abutting, I believe there's a church parking lot here. So it's abutting the church's parking lot. And then they have there's a parking area in the back of the structure. Exhibit 3, zoning map. The property is zoned NC, that's neighborhood commercial, or sorry, neighborhood center. And it's also in the historic district overlay. So this proposed project was presented to the Historic District Commission and received I believe they received a COA. I'm not sure exactly when that took place, but the applicants could speak to that whenever they get a chance to speak. Exhibit 4 is a Google Street View image showing the existing structure on the property and then their driveway coming off of East Boulevard to the back. In the back, you can kind of see it in dark shading in the shadow, but there's a fence back here, and we'll talk a little bit more about that in the next slides. Exhibit 5 is the variance request, and it's a variance from, again, Article 20.9 to waive the required landscape yard. So in 20.9, it states in letter B, when a landscape yard is required by the section being Article 20 that requires landscape yards. So when a landscape yard is required by that section and the site does not have a landscape yard or the existing landscape yard on the site does not meet the standards of the section, then you have to bring it up to the current standards or install the required landscape yard when there's an addition, number 2, in addition to an existing principal structure. That's all it says. It doesn't matter how big the addition is. It could be a 1 foot by 1 foot addition and you'd trigger a landscape yard requirement. So any addition to an existing building, if you don't have a landscape yard on the property, you're required to install one or bring what's there up to compliance.
Can you go back to the previous picture, that one? So what they're proposing is not having the landscape yard, right, that I see right here?
The landscape yard is required at the back.
Oh, at the
abutting
back,
residential
okay.
use. Yeah. So I'll show you that in the site
All right.
plan.
Sorry, I misunderstood.
Next slide is Exhibit 6 site plan. So here's the existing structure. There's a proposed addition to the rear. And then the required landscape, this pointer's being glitchy. The required landscape yard would be abutting the residential property to the rear and is required to be 25 feet wide for the zoning district and the use that's proposed abutting the single family residential uses to the rear. And the 25-foot line is marked by this blue dash. I need it. So the current distance from the rear property line to the back of the existing building is 60 feet. The addition is about 15 feet deep. So they're doing a 15-foot addition off the rears proposed. The distance from the addition to the landscape yard that would be required to be installed is 19 feet. So, and then right now, or from the proposed property line or from the property line to the proposed addition would be 44 feet. So we have 60 feet currently between the property line and the back of the building. 44 feet would be proposed with the addition. And then if they do the addition, they trigger the landscape yard to be installed. The landscape yard would have to be 25 feet wide from the property line. And that would reduce that distance down to 19 feet here. And then this distance from the existing back of the building to that landscape yard, I'm not sure what that is, but if there was no addition, no landscape yard would be required.
Do they lose all their parking?
So, and that's, so there's there's different elements and regulations at play here. So you have the landscape yard requirement, but you also have off-street parking that's required for the use. And so they're showing 1, 2, 3, 4, 5 parking spaces here. And all of those would be removed with the requirement to install the landscape yard with the addition. Currently, here's how the parking is on the site from this Exhibit 7 kind of bird's eye view. They're able, right now with the space they have to work with, they've got parking along the back and then a few parking spaces against the building. Obviously, with the addition, the parking spaces against the building would go away, but also the landscape yard would be required and the parking along the back would be removed as well. So there's not space to do the addition and the landscape yard and provide off-street parking. Here's just another view, Exhibit 8, showing a different angle or view of the property. And at the back, you can kind of see the shadow of the fence. There's a fence along the property line. We've been told that that fence belongs to the residential property to the rear. I don't know if the applicant agrees with that assessment or not, but that's what we've been told by the adjacent property owner.
So what kind of a business is it?
Coffee shop.
So I'm not sure what's in there currently. I think it's already operating as a coffee shop, and what's being proposed for the addition is there'll be a coffee shop and bakery. So this additional space is to accommodate the bakery part of the operations, and it'll probably also support the coffee shop as well. So if you want to look at the rest findings, I can go through those and provide some more details
Yes, please.
when you're ready. Are you ready for me to go ahead?
Yeah, go ahead.
Okay. So 4 standards for granting the variance. Again, all 4 of these have to be met to grant the variance. Unnecessary hardship result does not sorry, let me make sure I'm reading this right. Yeah, unnecessary hardship does result from the strict application of the regulations because per Article 20.9B, the addition of the existing building triggers a requirement to install the landscape yard when one does not exist. The ordinance does not provide an exception for the addition trigger, so any addition, regardless of the size or location on the building, would trigger compliance with the landscape yard requirements. Article 37.8 allows certain non-conforming site elements to continue, stating unless otherwise stated elsewhere in the ordinance. The provisions for non-conforming site elements, because the ordinance says unless stated elsewhere in the ordinance, and it states in Article 20.9 that compliance with the regulation is required with the building addition. So even though there's an opportunity to not require that landscape yard based on non-conforming site elements, because they're doing the addition, that supersedes the non-conformity clause in Article 38. The NC zoning has a minimum parking requirement for restaurant use. It requires 1 space per 500 square feet of floor area and then 50% of any outdoor seating area when within 400 feet of a neighborhood 1 place type. The residential property to the rear is in a neighborhood 1 place type, and the plan submitted by the applicant, this says 10 parking spaces. That's a typo, I believe. Shows it showed, what was it? I think it was 5 parking spaces.
27?
Right? 1, 2, 3, 4. Yeah, 5.
So instead of 10, it should show 5.
Yeah, the applicants show 5.
Okay.
Okay. There's not space between the rear of the building and the property line to install the required landscape yard and to meet on-site parking requirements. The strict application of the regulation would require parking and vehicular maneuvering to be removed such that the property would not be able to meet both landscape yard and parking standards. The hardship does result from conditions that are peculiar to the property. The existing site was originally constructed in 1918 for a single-family home. There's approximately 60 feet of space between the rear of the existing building to the rear property line. The required landscape yard width is 25 feet, leaving approximately 35 feet for parking spaces. 35 feet for parking spaces and vehicle movement. And per the Charlotte Land Development Standards Manual, a one-way commercial driveway is supposed to be 20 feet wide with the standard parking space being 18 feet, 6 inches long. So in total, there would need to be 38 feet for parking and maneuvering space. Standard space is, standard parking space is, that's an added sentence. There's 44 feet between the rear of the building line and the rear property line. In 16, you can just strike a standard parking space is. And that sentence should begin with there is 44 feet between the rear of the building.
Okay. Thank you.
This is the unique placement of the existing building on the lot results in conditions peculiar to the property such that there is not space at the rear of the building to meet both on-site parking requirements and landscape yard requirements, regardless of the proposed addition. The hardship does result from actions that were taken by the applicant or the property owner because the building is already in a non-residential use and the existing non-conforming lack of a landscape yard is allowed to continue with the existing development on the property. It's the applicant's proposed addition that triggers the compliance with the landscape yard regulation, thus creating the hardship. The requested variance is not consistent with the spirit, purpose, and intent of the regulations such that public safety is secured and substantial justice is achieved. The intent of the ordinance is to provide landscaping and screening between residential and non-residential properties when additions are made. And the variance would allow the existing lack of a landscape yard to remain despite the proposed addition, which would not provide substantial justice to the abutting residential properties. And the proposed addition is to the rear of the building. It's about 15 feet deep and would shift the rear building wall from about 60 feet from the rear property line to 44 feet from the rear property line. And that concludes staff's presentation. And I'll take any questions or we can go to the applicant.
I mean, 2 of the 4 staff's and then.
Yeah, and in staff's opinion, they would meet 2 of the 4 conclusions of law.
Are they using it now like for patrons to park back there? Is that what they're using it for? Or-
I'm not sure who all parks there, but I mean, I would assume that there's at least patrons, if not also employees.
It's an awful small space, even for what they've got there now. Looks to me. Okay, any other questions or comments for staff? All right, thank you very much. All right, we have someone to speak for this. Please step forward. Okay. Do you solemnly swear or affirm that the evidence you shall give to this board in this action shall be the truth, the whole truth, and nothing but the truth? So help you God. And if you would state your name and spell it for the court reporter, please. Thank you very much, Mr. Smith. You may continue.
There it is. Okay, is this all right? Okay. Okay, that brings it up. And if you want, you can scroll this up or down to change slides.
Right.
Okay. Oh, and there's. Yep.
So, thank you, Mr. Kinley, for setting me up. Good morning, everyone. My name is Jamal Smith. I'm an architectural designer for Architect Builder Group, and I'm the project lead on the 1218 East Boulevard project. I'm here today on behalf of the property owners, Ryan and Abraham Khalil, who operate Backyard Brew, as we discussed. So firstly, I want to kind of go back through the site background. So the building that was on the property was originally constructed in 1918 as a single family home. And a lot of the issues we're having is because the lot's width and proportions reflect its residential origins. And records confirm that the building has functioned as a commercial property since at least 1998. So it's been a commercial property for quite some time. The gravel lot that is in question was actually constructed under previous ownership in 2017. So you can see that from the 2014, there's just trees back there. 2017, you see here. And since then, since the gravel lot's construction, the property has actually seen two other owners prior to its current owners, with Backyard Brew opening in late 2023. So, questions on the project's necessity. So, of course, there's business pros to that. Expanding the kitchen, having more seating space, equipment, room for staff and patrons, things like that. But one of the biggest reasons for the addition is to improve ADA accessibility and for those with mobility issues. So the footprint of the addition back here is about 500 square feet. And because of the building's history from being built in 1998 or 1918, a lot of the facility is not compliant with the ADA requirements. So a big part of the addition is having the ramp here on the right side of the building. And the addition, it leads directly to the addition. Without that addition, there's not enough room to have the ramp connect to the existing property. There's currently no way of getting to the property if you are in a wheelchair, unless you're assisted. So in addition to that, there's a lot of tight spaces in the building. On the left here, you can see a hallway. That's the main thoroughfare through the building. And the image next to it, you can see that a similar view of the same space, kind of opening it up, allowing people to circulate better throughout that space. And also, in addition to that, the restroom currently is not ADA accessible. So we would provide an additional restroom and then also provide a larger ADA restroom for those with mobility restraints. In addition to that, there's also fire protection upgrades that are taking place. So you can see here in the red, that is a fire stair that would be constructed on site. Currently, there's a very steep stair through the center of the building. Obviously, it's not fire protected. So here, again, we have the stairwell, and that is also a fire stair for the adjacent property. It prevents the fire spread because they're so close. And then obviously too, with the addition, we would enclose the porch, which is just to improve year-round usability. Okay, so again, the variance request is pertaining to the landscape yard in the rear, the 25-foot landscape yard. Because we are neighborhood center, neighborhood commercial, and the property to the rear is N1C, so single family residential, we would need some type of buffer back there to between the two uses. So kind of going through the criteria that we all look at for the variance. As mentioned, the straight application of this landscape yard is in direct conflict with UDO section 19.2, the vehicle parking space requirement. So with our square footage at around 4,800 square feet total, we would need 5 spaces, which is impossible to accommodate with the landscape yard. And I do want to point out as well, so even without the addition, that landscape yard would prevent any parking from being on site because with the minimum turning radius, which is quite small actually, you would still be encroaching upon that landscape yard there. And then compliance with the one would force non-compliance with the other. So in either case, there would need to be a variance. Hardship is peculiar to the property. So again, with the property's origins being a single family home, the property is a lot more narrow than any modern commercial lot. And the existing building's placement and rear parking configuration leave limited room for the landscape yard. So we're already very limited on the drive-in space as well. So it's just a very tight space. And with it being a commercial property that was once residential, there's not much we can do there. Hardship was not created by the owner. Again, both the dimensions of the property, the building itself, and the parking placement the gravel lots placement all predate the current UDO standards as well as the current owners. As I mentioned, the rear parking area was constructed in 2017 under a different owner. So the owners are working under inherited site constraints. The project is consistent with UDO's intent and values. Preserving a neighborhood serving commercial use. So we're expanding upon a small local business, improving upon accessible and safe circulation, again, expanding those narrow passageways and providing access via the ramp. We are keeping the parking at the rear rather than displacing anything in the front. We're supporting multimodal access and continued walkable neighborhood services. I'll kind of touch upon that a little more in the last slide. And we're avoiding disruptive redesign of a constrained historic site. So there's little to no effect on the front facade. And we've already gone through the HDC process. We've gone through a few different cycles, and we landed on a design that they're very happy with, actually. So keeping the parking in the rear would obviously assist with that. So, and lastly, the project benefits the community. So we have, again, better access for patrons with mobility limitations, preserving the character of the neighborhood, allowing an older building to function safely and more inclusively. We're better serving the existing neighborhood demand. And this is a very popular coffee shop if you have never heard of it. So having this addition would definitely help keep the traffic through the building running smoothly. And then I also want to point out that there's no rear patio or customer outdoor space that is being proposed. So there won't be any additional disturbance to any neighbors in the rear of the property. No additional noise or light or anything of that sort. So proposed mitigations. So we've been trying to figure out different ways to possibly find a middle ground. One of those is having additional vegetation screening where possible. So we could possibly spare about 5 feet or so to add maybe some vegetation while still providing the parking. Providing a new rear screening or a fence between our property and the adjacent property. As mentioned, the fence that was seen in the rear of the property there is on the neighboring lots side. So we could also provide fencing on our end as well. We would consider bike parking or other multimodal improvements. So just providing additional options for parking. And we would limit the operating hours to 8 p.m. to prevent any nighttime noise spillover for the residents behind us. And also, I do want to propose, if determined more appropriate, we would be willing to remove the parking, and have the variance relief from UDO section 19.2. But we feel that this was a more appropriate route. There is street parking along Dilworth Avenue here and Charlotte Drive here, as well as the lot across the street at the Kenilworth Common. Obviously, if we were to pursue that route, we would have to speak with the owners of the property and get approval for that. But again, I feel like this is a better solution, just the variance for the landscape yard. And in conclusion, the project proposed is necessary and beneficial to the community. The hardships presented were not created by the owners, but were inherited. Again, the lot was created in 2017, so the parking gravel lot, so predates the owners. Its unnecessary hardship would result from the strict application of the regulation. A variance seeks to simply maintain the existing conditions, reducing the overall scope of the project. So essentially what we're asking for is to keep things as they are to prevent additional work from having to take place. And then no reasonable solution can be provided without the implementation of this variance. So with that, I'd like to open up for questions and thank you for your time and consideration.
Thank you, Mr. Smith.
Hamilton, as soon as they pull a permit, they're gonna have to meet all the ADA requirements, aren't they?
Yeah.
So you're proposing I'm looking at this picture on the left-hand side. That's the sidewalk that you're planning to enlarge, do something with? Or,
That ramp is not there currently. It's just a fence. So that ramp leads directly into the addition. Without that addition, there's not enough space for that to have the appropriate slope and go into the building
so this picture is what it's gonna look like when it's finished or what it looks like now?
when it's finished.
How many parking spaces are you giving up?
Right now, I think we're giving up 3, which are just next to those stairs.
Parking.
And maybe
And there's no parking on East Boulevard, right? 'Cause you
there's bike
have to
lane.
Park in the bike lane,
Mhm.
4-lane road now, it's a 1-lane road.
Yeah.
So you can see there, that's where those 3 we're giving up are.
All right, any other questions for Mr. Smith?
Do they get any parking from the church next door?
Right now, no, we couldn't reach an agreement on having that additional parking, but there's just the street parking on the blocks away, a few blocks away.
Straight compared to the park.
Okay, thank you, Mr. Smith. All right, someone's here in opposition? Okay, thank you. All right, thank you for your patience with us today. It's been a long agenda. All right. Do you solemnly swear or affirm that the evidence you shall give to this board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, if you will state your name and spell it for the court reporter, please.
Mary, Merrie. McGrath, Mcgrath. And Russell, was this ELL? Ruckterstall, Ruckterstuhl.
Okay, you may begin.
All right. My name is Russell Ruckterstall. I live on East Worthington Avenue, which backs up onto this project. And I'm here to speak in opposition to this variance request.
Excuse me, Russell,
Just the fence.
just the fence?
Yeah, one would be good, thanks. Yeah. So this existing rear parking area was never permitted in 2017 when it was installed by the previous owner. The aerials that the applicant showed it pretty clearly that it was just a regular backyard for the residents with multiple trees, and it was replaced with a gravel parking lot. And staff has been unable to find any building permits or HDC approval for when that gravel lot was put in. So because it was installed without permits, the parking lot's legally non-conforming, and the applicant can't rely on the current configuration to justify a complete relief from the landscape yard requirements. Under the legacy zoning ordinance that was in effect when the gravel lot was put in, it would have required a Class C buffer, which is a 10-foot separation with either planted strip or a solid fence. So had it been legally installed, that 10-foot buffer would have been required at the time, and it was never provided. The purpose of that buffer and the UDO landscape yard is to protect the adjacent residential properties from noise, light and headlight glare, visual disturbance, and physical impacts from vehicles. The neighbors have experienced all of this. And here's a photo of some of the damage to our neighbor's rear fence caused by vehicles parking directly against the property line. And this is the harm that the buffer is intended to prevent. The hardship of the variance application, I believe, is self-imposed. The UDO landscape yard requirements triggered because of the building addition, not from any unique physical condition of the land. The applicant chose an extension layout that pushes the parking demand into the landscape yard area. Parking minimums do not override landscape yard protections. Both must be met. If the board is inclined to grant relief, I request that specific enforceable conditions are imposed to protect the adjacent residential properties, many of which the applicant outlined in his slide. One would be that there would be no future increase in parking capacity beyond what's shown on the drawings. Second, that they provide a reduced landscape yard, a planted buffer, the maximum size that would allow for the parking to still remain, to provide the visual and physical protection for the neighbors. In addition, the gravel lot is going to be required to be paved as part of the historic district approval. It is at a higher elevation than the properties backing up to it, and we've all experienced a lot of stormwater runoff. We would ask that they require the adjacent stormwater controls be installed as part of this approval of the parking area. A final condition, which hasn't been mentioned yet, is the trash and recycling and outdoor storage has not been located on the plan drawing, and we would like to have it included as a condition that it be screened and located away from the rear property line to prevent odor, noise, and visual impacts on the adjacent homes. And I want to be clear that the issue is not with this particular applicant, but whatever is granted today will apply to all future owners. So, and they may not be as considerate or understanding. So the variance runs with the land and not the applicant, and that is why strong conditions are essential. So for these reasons, I respectfully request that if the board grants relief, that you impose some conditions that I've listed along with some long-term protection for the adjacent property owners. Thanks.
Can you please articulate again what your suggested conditions are?
Okay. The first one is not to further increase parking capacity, that if they are allowed to put in, that they don't go beyond what they've shown on the plan, that's tied to the variance request, that what the number of parking lots shown on the plan is what they're limited to in the future.
Okay.
Just so they can't restripe smaller spots or any future owner do any shenanigans around that. Second, I asked for the landscape yard as large as can be accommodated with the parking, and that it be a planted buffer to provide screening.
Okay.
The third one was stormwater controls with a new paved lot. And finally, trash and recycling and outdoor storage location restrictions.
Okay. Thank you very much. Ms. McGrath.
Yes, I'm the backyard neighbor to Backyard Brew. And they're great people. And we love having it in the neighborhood. It is a very popular coffee shop. They had it's since moved, but they had a weekly run that was attended by hundreds of people every Thursday morning at 5:30 a.m. And my dogs let us know every Thursday morning, but that's not there anymore. But they do open very early. And our bedroom is in the back of the house. And when the car first comes into the driveway, the lights do shine on us. And in our bedroom, our house is elevated. And their back door is also elevated. So when the employees are coming out, they're looking right at us. And when I'm letting the dog out at 5:30 in my sleepwear, customers are walking and can see everything. So it has been a hardship. It saw where they hit the fence. We had that put in when we moved in, excuse me, in 2017, I believe. And I'm not asking for the UDO or anything close to that. I don't understand why there's not some vegetation. And I think it would be great to have, like 15 feet, because it does seem that the further away they get, the more they can see into our yard and our house. And again, with the runoff, we have runoff problems from Dilworth Road. It's up East Worthington is all downhill. So everything runs off into our yards. And I would appreciate if they fix that. And really the garbage, we talked about that. So I just wanted to tell you what our experience had been with having them there. Excuse me.
Thank you very much.
And I just want to add, there are some limitations of the historic district, how solid the fence can be. They require certain open areas in the fence. It can't be a,
Yeah,
So-
it's the alternating
yeah,
type
picture.
wood.
Yeah.
Yeah, I see. Yeah. Okay. Yeah, historic preservation. Yes, thanks. Okay. All right. Anything else you'd like to share with us? All right. Any questions from the board for these two? No? All right. Thank you very much.
Rebuttal.
All right. Rebuttal from the developer. Would you like to
There
have any?
also witnesses in favor.
He didn't want to show.
Other than the applicant, or the agent? No, I don't believe so.
Anyone else in opposition? No. All right, Mr. Smith, would you like to have anything to say to their requests for conditions? Sure.
You may, is the owner here as well? Property owner, you guys, I think if you're gonna ask about conditions, you may need the
Okay,
owner
property owner,
to
if you'll
speak
step up,
rather than
please.
the agent.
And we'll swear you in. Mr. Khalil. All right, do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth, sir? You got it.
Yes.
And if you'll spell your name for the court reporter, please.
Ryan Khalil.
Okay, thank you very much. All right, you may respond, gentlemen.
So, after hearing these concerns, I fully understand, completely understand those are reasonable, requests. I do think that for sure we could accommodate having that, reduced, landscape yard. And I do think if we were to provide vegetation at the rear between the, fence and the lot, that would definitely, help with drainage. And then we could also address that in any other way, if needed. As far as the outdoor storage, if you were, if I go to, so right now, there's an area here that's not being used, and that there's also a fence already along this side. So we could provide additional screening for any outdoor storage or anything that needs to go out there for that area.
Oh, how is your trash? I mean, do the trash trucks come up this little driveway?
No, not at all. They actually come on the main street on East Boulevard. That's all the businesses actually on East Boulevard. Everyone has to roll their bins out.
Oh,
They
so
don't
you have
they don't-
roller bins. Okay.
Nobody really has the big dumpsters along East Boulevard.
Okay, but you say there is a place that you could possibly screen.
Yes,
Okay,
potentially back here, yeah.
all right.
Additionally, the paving, that would be something that would have to be run across the HDC.
Correct.
So I would be able to look into that, but that is something that they would have to look into as well. And then lastly, for the rear windows, we could provide some sort of window treatment, whether that be a film or just blinds or anything to help prevent the unobstructed views into the rear residence.
Is there any stormwater requirements being installed?
Not currently, no.
Okay. Does anybody on staff know that if putting down pavement would trigger any kind of stormwater retention? Maybe.
I think that has to do with, I read that a long time ago, but it's like 15,000 or more, 20,000 square feet.
Okay.
If you're building or if you're putting pavement.
They're asking about stormwater, John. Is there any requirement for the stormwater runoff?
I do not know, what the stormwater requirements would be for this type of
But that will
development.
be looked at when they submit.
When they submit their land development plans for review, stormwater staff would review those plans and to ensure compliance with the ordinance.
All right, so to be clear, you would be accommodating if we put into effect some provisions that include some kind of a landscape buffer, a planted buffer, and maybe a new fence or your fence on your side and a landscape buffer, some plants. That you
Also wanted to mention that there's currently a staircase here, that would actually be gone. And it'd be pushed to the side here. Which is why we needed the extra space to add this fire staircase and as well as the ADA ramp. So you wouldn't have people. Yeah, I know, I understand.
Okay, so, and you will do some trash concealment.
Yes.
All right, and you would agree to not increasing any more parking spots if we agreed to this?
Just to clear, how are you gonna deal with your loss of parking? You're gonna lose, what, 40% of your parking?
So, believe it or not, we actually have a lot of people that are just locals that are walking to us. So from the neighborhoods, from the different offices. Right now, a lot of our current clients are actually just parking all over the place. What she was mentioning before, Mary, right?
Yeah.
So what Mary was mentioning before, we used to have this run club. It actually started off with 4 people, ended up being like 400 people. Kind of got out of like crazy. I don't know what happened, but anyway, eventually they moved to a different space down in South End. And kind of like we made kind of verbal contracts with across the street, Harris Teeter, because they're like the main anchor tenant there. And then we tried to be as synergetic as possible. And yeah, we were trying our best to work with them, but they're all young people that are just like really loud in the morning. Yeah. Oh, I know. But I'm actually glad that they're kind of like not doing that anymore. So I mean, in my mind, we were trying to be like that third space for people that are local. Our goal isn't to be like, oh, we're like Carowinds and we're gonna have this huge parking lot. And we're gonna have people from all over the state to come to us. So, yeah, that's in my kind of like.
Okay. Thank you very much. Any questions or comments?
I have a couple, I guess one clarification. So we talked a lot about parking. The minimum required parking needs to be on site. If any additional parking outside of beyond what's required can be shared on on the adjacent properties that they're referencing. So there's a minimum that's required based on the square footage that you have to have on the site. If there was on-street parking available, then the parking that's directly abutting or in front of your property can count towards that minimum. In this case, they don't have any on-street parking available. So all of their required parking has to be on-site. Just wanted to make that clear.
And what is that minimum, John?
It's 5, I'm assuming it's 5 spaces based on the evidence and testimony that you've heard today and what they show on their approved plan or on the CO.
So they really couldn't, I mean, I guess what we're making sure is that they are going to be, if they would agree to just the 5 spaces, not trying to.
Correct.
increase
And
that.
then additionally, we talked a bit about the addition and the landscape yard. And again, the addition triggers the requirement for the landscape yard. If there was no addition planned, then the landscape yard would not be required or triggered. So things would just basically be able to continue as they are. But any addition whatsoever would trigger that. So even if they did a smaller modification to the building to accommodate maybe the accessibility ramp, for example, that would still trigger the landscape yard requirement.
So but then what we're saying, if we approve this, is that we are eliminating that requirement for that landscape yard, but they are agreeing to put in a fence and also some plant buffers, or can we do that?
You can impose conditions on a variance request. The board has the authority to do that. And so that's perfectly reasonable for you all to do. I would suggest that maybe establishing a minimum width for the area for landscaping, just to say like how much space they have to be able to provide that landscaping. That way it can be demonstrated and illustrated on their plans that they submit for land development, and our zoning reviewers can confirm that that condition has been met. You just say that you're going to provide some plants.
I get it.
They could plant the plants wherever on the property.
If I may add too as well, I'm more than happy because we're owner operators of the facility itself. More than happy to oblige any of our neighbors and making sure that we're doing the right thing for everybody involved, honestly.
So John, based on the requirements that they have for turnaround space for cars, what would you suggest that buffer be?
I don't have a scale drawing in front of me to be able to measure it out.
It's 44 feet from the fence to the.
There was 44 feet from the property line to the rear of the addition.
Right.
We could
And-
do, from our findings, we could do about 5 feet. And we can also impose, if you need anything barrier wise to like stop any vehicle from getting there, we can do that as well. So whatever works basically with the city as well as HTC would be more, I'm more than happy to.
If,
I don't think they're gonna let you do a bigger fence.
That was my next question.
Yeah.
Yeah.
yeah, from the technical aspect of, obviously the Historic District Commission would have to weigh in on it, but from a zoning perspective, they could do a taller fence than what, 6-foot or 8-foot fence that a residential property is limited to. But obviously that would have to go before
Yeah.
the.
But the
Historic
5, but
District
we could say that the landscape buffer could be 5 feet.
Yeah, the 5 feet wide for, to provide space for landscaping, and 5 feet is the same width that we would use for like in a commercial area between parking lots, and you have to have a little landscape strip for some shrubs or something along a parking lot. 5 feet of space is adequate for landscape.
So we could just call that the landscape planted buffer. That's what we were,
A 5 foot wide
5 foot
landscape
wide.
buffer, and then if you want to specify the number of trees or shrubs per linear feet, you could, but you could also just leave it as is. But if the idea is to create some barrier so that a car doesn't create, then you
Right.
probably want to have some other sort of mechanism for preventing the cars from going full,
So-
encroaching into that 5 foot wide space.
Minimum height on the mature shrubs. You don't want to plant a 3-foot,
right, yeah.
whatever, we need them to plant some sort of mature 8 to 10 foot holly or.
Can't
Can't do that?
go too high because we have power lines there. So,
Oh, then there's that.
yeah. But I would say if we can figure out ways to create that one buffer and also ways to block light, especially early in the morning, and if we do pave it, so you won't have the gravel sound, you won't have the light, and then hopefully the whatever vegetation that we kind of put in there would actually block the sound as well.
The
6 feet, so.
Yeah,
10, 11, yeah.
yeah.
So the board, whatever conditions you put, the land development staff would review it.
Yeah.
If, to make things maybe a little more clear for the applicant and for the reviewer, you could just have them say that the condition is referencing the whatever the standards are for landscaping for small maturing landscaping, because that's what is used whenever there's overhead utilities. So I would say something, I don't know exactly what the standard is called, but the land development standards for landscaping.
Well, that's kind of why I was asking. I mean, I don't want us to arbitrarily pick a number out of the air.
Right.
I'd like it to be as specific as possible for those.
Let me look and
homeowners and
see.
also for the developer, so that we're all on the same page is all I'm trying to, and the wording, I mean, I can,
Let me look and see what we have in Article 20.9. So for a Class C landscape yard, which is 10 feet wide, it's 1 evergreen shrub for every 5 linear feet. You probably can't fit a tree in 5 feet of space.
oh,
So I would stick with shrubs. But so it's 1 evergreen shrub for every 5 linear feet, and then there isn't a specific height for shrubs, but it would need to be small maturing
right.
shrubs to accommodate the overhead utility lines.
So if I'm not mistaken, I think landscaping is also within the purview of the Historic District Commission. So all of this is going to have to be in compliance with what they would approve.
A, B, and C. C is the Class C, but they're required at Class B.
It almost.
Yeah, I would suggest that you leave it open, because.
Right. I mean, as long as we say that it references the land development standards.
To
For the
give some
historic
flexibility.
and the
with,
flexibility, yeah, just. I just want everybody to be clear on what we're asking, because it seems like the business owners are willing to make some concessions. The homeowners are welcoming some of those concessions. As long as we're there, then I would, reference the land development standard for landscaping and let them tell us, because we know we're dealing with a small space of land.
Would y'all rather have a parking variance? And actually do the landscape buffer? And because the parking, y'all already don't have enough parking.
So believe it or not, when we were first thinking about this, that was actually one of the possible options. I'd actually have personally, I would love to be more walkable
Yeah.
and less parking. I don't even want cars back there. That's just, if I had to choose in a perfect world, yeah, potentially. That would be more amazing because I actually want to encourage more cycling, rollerblading, skateboard, anything else that's running, walking, rather than driving. So that's kind of, if that's even like.
Have you
doable,
offered
that's
to
not
pay
gonna
the
create-
church anything for the parking next door? Or does the church just not want you parking there?
It's on and off. So depending on the days, so they have certain events that we tell our guests not to actually park there. Then usually other times are usually okay.
Yeah.
So, and we have a pretty decent relationship with the church next door, as well as across the street, and some of the neighbors that have homes, I guess, off of Dilworth. Yeah, Dilworth Road. So, I mean, it's like what you said earlier. It's like 40% of the parking, but really, what's 5 parking spaces, honestly, for a cafe? And most people are coming in, grabbing a coffee, and leaving anyway.
Yeah.
So, yeah.
Okay, so what is it we need to do?
Well, I just wanted to give you a bit more information about the landscaping. So a Class B landscape yard, which is what technically is required, would be one evergreen shrub for every 3 linear feet. Class A landscape yard, which is beyond what would be required, that's 1 evergreen shrub for every 2 linear feet. And then again, the Class C landscape yard, which is 10 foot, which would have been required under the legacy code, is 1 evergreen shrub for every 5 linear feet. So obviously, it's
So
up
can
to the board, whatever
Yes, we
dimension
can
they
just
would want
cover
to
that by
use.
saying that we want to reference the land development standards for landscaping and let the historic.
Yeah, I mean, Steph, please help me here, but I'm thinking more in the lines of like, if you want it to be as frequent or as populous with vegetation, if you will, that it be, the highest level that it's compliant with the
Yeah.
Historic District Commission. Does that make sense?
Yeah, the condition would be like to provide a 5-foot landscape yard
Right.
with an evergreen shrub, however many linear feet you want. And according to the UDO, 2 foot is the most stringent spacing requirement. 5 feet is the most lenient spacing requirement.
Do Class B, we could do Class B.
And it would,
Yeah.
yeah, and then I would also add to that it is, whatever is also approved by the HDC, because that would, as Paige was saying, landscaping is their purview.
Okay, all right, I like that. That takes care of that.
I guess.
And they have agreed to do some kind of concealment for the trash cans. That was one of the things
Yeah.
they said they would do. And
Well, I was gonna say, if you want to be less specific about the spacing, you could just leave the spacing of the shrubs up to the HDC.
well, that's fine with me. I mean, I just want to make sure that the wording we put in here gives the Historic Landmark Commission whatever purview they have to renew this, but not make it onerous on everybody. But to state what we want as a condition of us approving this. Does that make sense? So however you want to word that, that's fine with me. I'm not an official wording person for those kinds of statements.
I appreciate that. Yeah, because the back and forth is it's gonna tire everybody out.
Right, and I don't want that. I want you
Yeah.
to be clear on what the expectation is. I want the homeowners to be clear on what the expectation is, so that when it's all said and done, everybody's not going, wait a minute, that's not what I agreed to. And that's all I want to make sure of. So if we do this, that we say, however you referenced it, with land development standards, one evergreen, you said a Class B, as long as it meets the standards of the Historic Commission.
My recommendation would
Okay.
be just a 5-foot, for the commission to provide a 5-foot landscape yard with the spacing to be determined by the HDC.
Okay, that,
And I think we say a minimum of a 5-foot
And
Case-
5 foot wide landscape yard, minimum 5 foot spacing.
Or no, I think a minimum 5 foot
Yeah,
landscape, yeah, and then we.
right. Yeah, for just the 5 feet, because that's what my question was, how wide it needed to be. Okay.
And then solid waste concealment, second.
Right.
Noted, then was there another one?
Talk about the,
Can you look up whether there is, what stormwater management is required? Are they exempt from stormwater management requirements for a small site? Because it's a small site?
That's probably a technical question that I am not, it's not under my purview to be able to answer or even
Right.
find the answer.
So, because if we say we have to meet the ordinance, but then they don't have to meet anything because it's below the minimum, they won't be doing it.
It's certainly possible that due to the existing development on the property, that's, certain sized additions may not trigger stormwater compliance. I don't know about the paving. Again, that's beyond my knowledge and expertise, and we don't have staff from stormwater to be able to
Yeah.
respond.
Right, I mean, I think stormwater is a very technical issue that generally would require expert
And
opinion.
I don't think as a board, we can require that they pave it as opposed to gravel.
HDC board's already required it to be paved,
Oh, okay.
as
I don't
part
think
of.
it triggers, I actually don't think it triggers the stormwater, but we'll do whatever we can to mitigate it. With the buffer should help, and then depending on how we slope and all that, because I don't want any runoff to go into your yard either. So I understand that completely.
Okay, well.
I'm human too. Yeah.
Okay, so I think that's what he said, with no increase in parking spaces, we know that. We talked about the landscaping and the buffer and the water runoff from the paved areas. I think, again, that's gonna be mitigated by the buffer. Trash concealment and, you haven't agreed to do some kind of screening, on your curtains or on your windows to,
If need be, yes, we can film it or make it opaque or whatever it is, colored glass, whatever.
so we'll just say, what? Light blocking window coverings, how's that? Does that work?
Say vision blocking,
Vision blocking.
allow light to come in, but just, yeah.
Yeah, just,
Here.
okay, John, you got that one?
Vision blocking.
You got to go?
Marshall's gotta go. Let's get a vote.
Okay, all right.
Need a vote or get Gary?
Okay, yeah, well, all right, so, all right, with these conditions that John has just mentioned, thank you very much. We'll go out of public. Yes, ma'am.
You brought- They wanted them to add those conditions as well.
It depends on each dog, because it's.
No, because it's the homeowners own the fence, so. I don't think we need another fence, right? We just have the landscape buffer with the shrubs.
We can add a fence, we'll add a fence.
Yeah, I can.
Okay, all right, so the addition of a fence, so that's another condition.
Historic district.
Historic district, per the historic district. Okay, Mr. Williamson has to leave us, so we're going to vote very quickly, I think.
Well,
Close.
yes, we need to close the hearing. We need to
Yeah.
put the criteria up.
Oh, you mean our 4 standards? Is that what you're talking about?
Yes.
Okay, well. So what we,
Can I make a motion?
can he make a motion?
Can you deliberate on the facts as to what you're relying on for your
Oh.
motion?
Well, we're relying on the unnecessary result from the strict application of the regulations. I agree, because without. If he builds it, he's gonna have to, he can't build it without us approving it, so that's the hardship. Conditions that are peculiar to the property, yes, the size and location, and it was built in before any of the UDOs were even thought about. The hardship didn't, well, the hardship did not result from actions taken by the applicant. It did, but they've agreed to conditions to mitigate that. No, I can't say that.
The variance, in order to grant a variance, it has to meet all criteria.
All right, then I'm gonna say it doesn't result from actions taken by the applicant. I think yeah. And then the request of the variance is consistent with the spirit, purpose, and intent of the regulations. So I think we're okay with the conditions that everyone has agreed to. Is that okay?
To grant a variance, it has to meet all of the criteria. So the board really needs to demonstrate facts that support that each criteria is met, and it is up to the board.
Number one and number two have been outlined by staff, and so the conclusions of fact, or the statements of fact and conclusions of the law, should be covered in number one and number two.
Right. I agree with that. Okay. And the hardship, the hardship does not result from actions taken by the applicant.
On 17. So in 17, you would need to strike the latter part of from our finding.
Let's get.
Let's vote on
Let's
the,
get the vote first.
Oh, yeah.
we'll vote,
Sorry.
then we'll change this. Okay.
Well, but we can, I mean,
Yeah,
this
we
is
can
a good
always-
way to
yeah, we could.
deliberate. Let's just talk about this.
Okay, so the hardship does not result, we're saying, from actually saying about applicant or the property owner because the building is already a non-residential use and existing non-conforming lack of a landscape yard can continue with the existing development on the property. Can we just take out the last sentence? It is the applicant's proposed addition that triggers compliance with the landscape yard regulation, creating a hardship? Or just landscape yard regulation, period, and then we'll just strike
With the rest.
creating the hardship. How's that, John?
Sorry, I didn't understand what.
Well, all we're doing for number 17, we're adding the word not, and we're striking creating the hardship. So that,
I think that the board, needs to provide facts that support the facts that the hardship did not result from actions taken by the applicant or the property owner. What facts is the board relying on?
well, because he's not increasing the number of parking spots, he is providing a landscape buffer and planning, he's concealing the trash and he's doing blocking of the inside of his restaurant with window coverings.
Page wants to go to number 3.
I know, but but if we leave it, then we can't approve the variance because they've all got the match. So
I'm just saying, that's what Paige is thinking. Well, let Marshall go and then we can, yeah, I got a few more minutes.
yeah, we're talking about Marshall. Marshall, do you have any suggestions for this that will get us out of this?
Give them a parking variance. We had this discussion before. You can't change the application after you're here.
No, and a parking variance would that'd be a whole separate variance, separate hearing, separate notifications, all, we'd have to start over basically if we were to do a parking variance.
Terrible idea. Yeah. So
In the previous variance, the conclusions of fact and or conclusions, the statement of fact and conclusions of the law use the following statement in addressing it, that it does not result from actions taken by the applicant or the property owner, in that particular in that specific area, the applicant did not create the lot or the specific conditions related to the parcel that restrict the development area of the lot. So if we use those sentences as a framework, not necessarily taking those words, but using that as a framework, we could use the first part of that sentence.
So remember, you have to concentrate on this particular property that's in question. You have to, in order to grant the variance, one of your conclusions needs to be that the hardship did not result from actions taken by the applicant or the property owner. The board needs to provide and will ultimately need to find facts that support that conclusion. Realize it's just deliberation and you haven't voted on the variance yet, but ultimately you have to support your decision. And that's what I'm asking for on the record.
So staff has said that because, let's see, it's the applicant's proposed addition that triggers compliance with the landscape yard regulation, creating the hardship. So do we agree with that, or is there something else that created the hardship? Is it the site constraints that created the hardship?
No, it's his request to build onto to make an addition to the property. Because it triggered, then it goes back and it triggers all of the current regulations that were grandfathered into this property prior to that.
Number 10 says the ordinance does not provide an exception for the addition. For the trigger caused by the addition. Right? And so that strict application of the ordinance is causing the hardship.
I mean, that supports your conclusion for number one. You have to conclude all four of these
Okay.
in order to grant the variance.
So we got one.
We want to approve the variance is what we want to do.
Hardship.
Well, 2 is easy, right? That's
Yeah, 2 is easy.
easy.
Okay.
You want to be able to, what we want to be able to say is, right, the hardship.
It's not about what the board wants to do. It's whether or not the board can make the appropriate conclusions
Hardship.
supported by findings of fact.
This is what we have for one. This is what staff had. The top part is what staff had for two. And then this is number 3, and then this one would be number 4. So this one and this one would be the ones that you guys would need to work on.
Okay, can you put those all up there at the same time?
It's 2 separate slides, so I don't know if I can have both at the same time on here, but I can go back and forth if you want me
Slow
to.
down.
Which one do you want me to go
Let's
back
go
to
3.
3?
Let's go to 3.
All right.
That's the hardest one.
Court had a train of thought he was working through a minute ago and may have been on, you may want to
Yeah,
get
he
back to
was
what
looking
his
at
train of
this
thought was.
because it says here, the hardship does not result from actions taken by the applicant. Applicant did not create the lot or the specific conditions related to the parcel.
I mean, essentially, building a sidewall too tall triggers
Right.
triggers at variance.
True.
So that's an action that triggers. So I mean, I don't know that that's necessarily saying doing an addition automatically triggers necessarily. I don't think we have to look at it that narrowly. Otherwise, every variance would be triggered by something.
Well, can the last sentence here, the unique placement of the existing building on the lot results in conditions that are peculiar to the property. And there's not enough space but we are providing enough space with the 5 foot to both meet the on-site parking requirements and the landscape requirements of the proposed addition. Are we not? I mean, that's what we're doing. What we're saying is the unique placement of the existing building on the lot results in conditions peculiar to the property such that there is space at the rear of the building to meet both on-site parking requirements and landscape yard requirements regardless of the proposed addition.
Yeah, I think that's.
So if we take out the word there is not, and just leave it, there is space at the rear of the building to meet that I mean, even though we've changed it to 5 feet, that still meets the on-site parking requirements and landscape yard requirement, regardless of the proposed addition.
The variance is from the landscape yard requirement. The landscape yard requirement is 25 feet. You're discussing a condition for it to be 5, but you're not meeting the landscape yard requirement. It's 25 feet. That's what you're granting the variance for.
No, you shouldn't have to make any changes to this first 2 bullets here because that's been staff support and matched
Okay.
up. So it's really about how do you arrive at the conclusion of does the hardship result or not result from actions by the applicant or the property owner? If it's not resulting from the actions of the property owner, what is it then that it's resulting from?
The size of the lot causes the buffer to be too large. So we will condition the variance based on a smaller buffer. Is that anywhere close to being?
I mean, it's ultimately up to the board. You have to make these conclusions and you have to provide facts that support them. The landscape yard requirement is 25 feet. So ultimately, anything less than that is not meeting the requirement and you're granting a variance.
I'm not looking at that. I'm looking at the fact that he's got 0 today and we're going to 5. You're coming from you're coming from the other end. I think we should come from the fact that we're at 0, we're going to 5, so we've gained something. I'm speaking out loud here. I'm thinking out loud. I think if we come from the other side, saying we go from 0 to 5, and what Marshall just said, I think I completely agree with. The hardship doesn't result from the applicant. The hardship results from the size of the lot and the fact that there's no existing landscape requirement or yard requirement. So that our new variance will in fact take a couple birds. It's going to solve the parking issue. It's going to solve the landscape yard issue as well. I think we come from that perspective. I think that works somehow.
The hardship does not result from actions taken by the applicant or property owner because the building is already in non-residential use and the size of the lot
Size of the lot requires a buffer that is undoable. And the approved variance
will increase that buffer to 5.
improves the situation
It
by
will- The parking and the landscape buffer.
requiring a landscape buffer and solving the parking problem.
The improved situation, I would save that for the spirit intent of the ordinance and stick with the size of the lot being the cause of the hardship
Okay.
instead of the applicant. It would be my suggestion.
Okay,
All right, so
so could we just end this, because the building is already a non-residential use and the existing non-conforming lack of a landscape can continue with the existing development on the property, period, and take out the rest of it?
Whoops.
I wouldn't say that can continue with the existing development.
Yeah, I would take
property.
that
Oh.
part out and just end it here
As a
and then add
justification.
in your additional sentences.
Okay,
Yeah, so the additional, already in low residential use, the owner did not create the existing site layout or specific conditions such as historic district,
reservation.
historic,
What is
historic
that?
district problems,
Requirement.
or existing buffer requirements. Under did not create existing site layout or specific conditions such as historic condition or existing buffers or lack of existing buffers.
Yeah, 'cause
Okay, John, does that work?
Page we have to worry about.
I think,
Okay.
yeah, the board, it's up to the board as to how you want to support your
Yeah.
decision. But the facts need to be on the record.
For Court, could you read, do you mind reading what you had one more time, just so we can make sure we have it correct?
Owner did not create the existing site layout or the specific conditions such as historic structures or existing buffers.
Period.
Yeah, period.
Sure.
Okay.
And then that's it. That's what we're saying for
Number 3.
for number 3.
Okay. Go next one here.
Yeah, so
So
the current situation
Right? It's fine.
has 0 landscaping buffer. And the variance now improves the situation by giving a 5-foot buffer. That's, I'm not Longfellow, but
No, the variance would provide a 5-foot landscaped yard.
which is consistent
Consistent
with spirit,
with-
purpose, and
with
intent of regulations.
Right.
Get paid by the hour here,
That's
by the
it.
guys.
Deborah, I'm gonna have to get you to get Gary to come in.
Oh, yeah, yeah.
If Gary comes in, we have to start.
Oh, no, get started. Okay, all right. John, you got all that now?
So number 20, we'd strike and replace with the applicant, or the variance would allow, what was it again?
The variance would allow for a landscape yard of 5 feet. That's what we said, isn't it?
He can go and we can ask the owners if 4 is okay, right? Yes?
I'll admit, I've never had that situation before.
Well, if we can get this sentence right, then we're good to vote. So
We can defer the conclusions of fact or this is the deliberations, right? We can
Right.
defer the findings and fact and conclusions law.
Yes.
Yeah,
can do
if you
that.
want
Yeah.
us to fine tune kind of
Yeah.
what y'all
Yeah.
discussing, we can present that to you all next month.
You just need to outline the conditions in your motion.
Yeah.
okay. All right. So,
There's 3 conditions, right?
right.
One is
The
5-foot buffer,
yes,
one is the plantings,
yes,
one is
the trash concealment, and the 4th one was the
the windows.
windows.
I make a motion to approve the variance with a 5-foot landscape buffer, plantings that meet the historical district's requirements and maximum height, window screening and screening for the trash and recycles.
Correct, that's the 4.
Was there addition of a fence?
Oh, the fence.
If approved by HDC?
Yeah, we do.
I have
Yes,
that one as
we
well.
did say that. So that would be number 5.
And if not approved by HTC, is that not required?
Yeah, if it's not approved, then it's not required.
Okay.
Okay, all right. That's the motion. Do I hear a second?
Word second.
Thank you, Court. All right, Mr. Williamson,
Williamson, yes.
Mr. Shea,
Shay, yes.
Ms. Sun, Court,
Or yes.
Dryden, yes. So we are approved. Thank you, Mr. Williamson. You may be excused.
I apologize.
That's okay. All right, Mr. Young, will you join us, please?
Move to defer the conclusions of fact and findings of law.
Conclusions of.
Findings of fact.
Findings of fact and conclusions of law, until next month.
Okay,
1 second.
thank you, Ms. Sun. Okay, Williamson approves. Shay,
Shay, yes.
Sun, Dryden,
Or yes.
yes. Court, yes. Okay, so we're deferring until next month, the correct wording of the finding of facts and conclusions of law.
Mr. Williamson was not present for that, so that would be 4.
He's
Right.
yes, way up.
Yeah,
He said yes on the way out.
I didn't hear that.
Okay. Okay. Okay, one more, variance number 2026-00021.
And for this one, I believe we just have the gentleman over here in favor of the variance request, and then staff was not recommending approval because we didn't find that all the variance criteria
Okay.
were met in our opinion.
All right, John, we're gonna take 2 minutes while you get that.
Sounds good.
We are actually paying these guys through taxpayer money. On the school staff.
15340 Smith Road. Okay, John.
We said for the record, Mr. Young is.
Oh, I'm sorry. Yes,
Marshall right now.
Yeah, let's take that down.
Mr. Young has joined us on the board today for our last case.
All right, so this is for CMS, Charlotte Board of Education, represented by Jeff Fuller of Optima Engineering for property located at 15340 Smith Road. This is down in the Still Creek, Palisades, kind of southwest Charlotte area. The variance from Article 17.2, letter F, number 3, which in the request is to waive the requirement that roof-mounted mechanical equipment be screened by an architectural element that is not visible from a frontage. So again, the property is kind of southwest Charlotte, just east of Still Creek, yes, well, 160, and then south of South Tryon Street. Exhibit 1 on the vicinity map shows it, that approximate location. This exhibit number 2 is an aerial map showing the existing building on the property. It's developed with an existing school building, and it's at the corner of Smith Road and Hamilton Road. Exhibit number 3 is zoning map. The property is zoned N1A. And exhibit 4 is a Google Earth view, just so you can kind of see the building. And then the equipment we're talking about is, you know, these units on the top of the building. The variance request is, again, it's from Article 17.2, letter F, number 3. That requirement says roof-mounted mechanical equipment shall be screened by an architectural element so that it's not visible from an abutting frontage. That's basically all that it really gives to go on in the UDO in terms of what the ordinance requirement is. So the request is to not have to waive the requirement that the roof-mounted mechanical equipment is screened from the frontage by an architectural element. Exhibit 6 is just the site plan showing the units that would be replaced. So the plan is to demolish the existing units, remove them from the building. That's what the top image is showing, is the mechanical plan demolition, and the bottom is the new work. And so they're going to be upgrading and replacing the existing units with newer units. This building was constructed in 2012. So the units are getting some age on them, and some are starting to fail. So in order to keep things running smoothly, they need to replace these mechanical units. The ordinance says that they have to be screened from view from the frontages with an architectural element. So a lot of times what you'll see is they'll attach panels, metal panels with louvers and stuff to provide that screening. Other buildings may have a taller parapet wall that provides screening. In this case, there's a bit of a parapet wall, but then there's also like louvered panels around the existing units that are on the building. When they're replaced, obviously they still need to comply with the UDO, which requires that architectural element to screen them, which again could be panels or the extension of the parapet wall, what have you. The ordinance isn't specific as to what that architectural element looks like or is. It just says architectural element. But again, from the frontages, this is Smith Road. The units are visible from several locations along Smith Road. This is at the main entrance drive off of Smith Road. And that's probably where things are the most visible, because there's not as many trees along the street that would otherwise kind of screen some of this. As you go further down Smith Road towards Hamilton, kind of going backwards on my slides here, but if you go closer to the intersection of Hamilton, the trees provide some screening, but that's not an architectural element, so that's not allowed to count towards the requirements. And their units are still visible in between the trees. And then in the wintertime, when there's no vegetation, they're a little bit more visible, and there's gaps in the trees as well. And this is a little further down at their other entrance.
John, are those the old units or those the new
These
units?
are the old units, so they haven't been replaced yet. And then from Hamilton Road, this is the driveway off of Hamilton into the school's property, and you can see those AC units, mechanical equipment at the top of the building as well there. And those again have the existing, those existing units do have the required screening. So standards for granting a variance, all 4 of these have to be met in order to grant the variance request. And if you want to take a minute to look over them, or I can proceed.
You may proceed.
Wait,
But
how, you have to explain how this got to your desk. How
Yes,
did
we
this
will-
case get to your desk?
We will get to that, yes. So, it got to our desk because the ordinance says you have to screen mechanical equipment. They are proposing to replace these units and not install the screening for the mechanical equipment. So that's how, so they're seeking a variance for that requirement.
How'd you?
Is that permanent?
How?
Have to be covered?
Yeah, it's already covered.
They're replacing them with new units though, and so the new units are bigger than what's currently there.
Oh, that's not what the application said. That's not what the application said.
They're bigger and they're bigger, heavier units that are gonna be installed. And that
Screening
means
would
they
come
would
out.
have to change the screening to go around them to accommodate the new units.
So they went to make an application for a permit.
Right.
And
Well, I don't know if they submitted a permit application yet, but they, at least anticipation of submitting the permit, realized that this was gonna be a problem for them. You can get the applicant to speak of whether, when they speak, whether or not the application for a permit has been submitted yet. I don't know if there's one. I don't think we referenced one in our documents. Regardless,
okay,
so the UDO requires rooftop mechanical equipment for all uses to be screened with an architectural element from view. Move this out of my way if I can. The standard applies to all buildings with rooftop equipment regardless of the structural design or age. Ordinance does not specify the exact design of the architectural element, providing flexibility for type and size and design of that screening. It's just some sort of screening that is architectural has to be provided. Article 37.8, 12G of the UDO states that the fact that property could be utilized more profitably or conveniently with the variance than without a variance shall not be considered as grounds for granting a variance. The cost to meet the screening requirement cannot be the basis for granting the variance. So there needs to be in other words, there needs to be other reasons for granting the variance beyond just the cost associated with it. The hardship does not result from the conditions that are peculiar to the property. The existing building was constructed in 2012, and the legacy zoning ordinance in place at the time was constructed in 12.303 says that utility structures and outdoor equipment to be screened from abutting property and public view from the street. And these existing RTUs or rooftop equipment have the required screening. The changes to the HVA systems resulting in larger, heavier units, structural limitations of the existing roof structure, and maintenance concerns could be applicable to any other building with older rooftop units. So that's the primary concern that staff has with this is that the hardship is something that could be applicable to any other building with older design and, needing new rooftop equipment. They would be, in the same sort of situation of having to make changes to the structural changes to support those new units. In addition to also have to provide that screening that the ordinance requires.
So these units would be suitable if they cover.
If they screened them, it would be fine to put in the new units. Yeah, we have no concerns with the proposal of replacing the units. It's the proposal to not screen them that is where we have the issue. Hardship does not. The hardship does result from actions that were taken by the applicant or the property owner. The applicant, while they're not responsible for the changes in the HVAC design that has produced equipment that exceeds weight limitations of an older structural system that was not intended to accommodate modern loads. However, the existing equipment is screened and the regulation is not new with the UDO and should have been taken into account when they were planning the project. The requested variance is not consistent with the spirit, purpose, and intent of the regulation, such that public safety is secured and substantial justice is achieved. The intent of the ordinance is to screen equipment from view of the street with an architectural element. And then while the mature trees on the site do provide some screening of the view along the streets, there are locations along both roads, Hamilton and Smith Road, where the units will be visible as clear as shown in staff's presentation, exhibits slide number 7 and 8. The changes to the equipment size and weight, structural loads, and the roof maintenance are not unique to the property, could be applied to other buildings, thus substantial justice is not achieved. And that concludes staff's presentation.
all right. Any other questions for John or any questions for John?
So. So did the existing units have screens?
Yes.
Okay. I'm just confused because I don't, rooftop screens were not really in 2012, I don't think we were putting rooftop screens on rooftop units for zoning in Charlotte. And, I don't know that number 12, that just conflicts with my memory and experience. Maybe I was getting a exemption when I was building these, but okay.
Well, I do know that a lot of conditional rezoning plans, because I used to work in rezonings. And before the UDO with conditional zoning, we oftentimes would have them add a condition to the rezoning plan that specified that any rooftop mechanical equipment would be screened from the street. What I pulled in number 12 is straight from section 12.303 of the legacy zoning ordinance. And it states that utility structures and outdoor equipment would be screened from abutting property and view from the public street. So there may have been a different interpretation at the time of how that was applied. I'm not sure, but the way I read that is that if it's outdoor equipment, it needs to be screened from the view of the street.
Now, the pictures you have here, are those screened or not screened?
These are screened. Now, some of these panels have been, it's like you can see there's a gap here.
Yeah,
They've been moved to allow access and maintenance because
okay.
they've had to do work.
But
on
that
these
was
to keep
kind of,
them
that
operational.
was the screening, okay.
Right, yeah, so like those are the screen panels. They're just shifted out of the way to allow maintenance and access.
Okay, thank you. Any other questions for John? Thank you, sir. All right, we have someone here to speak in favor of this, I do believe.
I think it's time to let the applicant present.
Yeah, that's the applicant.
Okay.
You pull up Google Street View of Chadwick Elementary School.
I'll let you hold that. I think something messed up. And if y'all want to use the later one, it's true.
Okay, sir, are you going to speak?
Do you have questions?
Yeah,
He's the
well,
one that knows the
if
most.
everybody who's possibly going to speak needs to be sworn in. All right, thank you. All right, gentlemen, do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes,
All
ma'am.
right, if you would each state your name and spell it for the court reporter, please.
My name is Stephen Daly, STEVEN DALEY.
Jeffrey Fuller, JEFFREY, FULLER.
Jason Crenshaw, JASONPRENSHAW.
Thank you, gentlemen.
Okay, did you want the aerial view? Street view?
Not Rivergate. I want to show a different school, just to show you what it would look like if we didn't screen it.
Oh, what was the other school?
But Google Street View is going to give you a better
What's the address?
image. It's Berwick Elementary, BREWICK.
BERK. BRE. Okay.
Thanks for your patience for waiting all day too, by the way, guys.
Yeah, please. Sorry it took us so long. Welcome to our world.
It's 59.
That's right.
Street view.
Yeah, Google Street View. Google Street View is the one.
You can do that one
Thank
from
you.
there?
Just look at your tab, where your tab is, Berwick Elementary.
Okay.
I was gonna say, just click maps, and you should already be up.
That way, just a touch, but click that way. That's a very similar layout of a school that doesn't have student units, and it's just something I want to refer to as we go through here, but then I'll quickly go through my presentation if I could.
Yeah, so patient is gonna be here.
Fine, okay.
Okay, right here.
Yep, sounds good. All right, for the sake of time, I'm not going to repeat a lot of the things that have already been said as part of this, but I did want to go into what our belief in the hardships are. I do want to point out that the UDO does show on the ground mounted a little bit more information in a diagram showing vegetation can be used in that case. So I'm curious if they don't give us a diagram on what to do with the roof, why vegetation can't be a part of it. I do understand that it says architectural elements, but why vegetation can work on the ground but not on rooftop equipment, I don't really understand. This is the assessment that we had done on the existing structure versus the new curb and unit weights. And this is without the screens. This is just curbs and units. We had one unit that was out of tolerance and we selected a different non-CMS compliant unit that would have worked for it in order to get down under. Now, why is this a problem? Because the screens weigh 500 to 600 pounds each. And now almost all of our units are outside of what the structural analysis told us we could do. So that's why we're in this position and why we're proposing going in without the screens on them. If we could put them back and it wouldn't affect the structure, we would do it in a heartbeat. This is what these things look like. I mean, when you look on the inside of them, these actually attach to the unit. That doesn't work anymore. That they won't allow you to do that anymore. So what adds to the weight is this second canted curb that you got to put above the roof curb that these things support too. It becomes a maintenance headache to climb in and out of those things. Garbage gets in there, all kinds of, it creates its own problems. It's not just the fact that they're screened from view, but they're not. Are these chillers? No, they're just DX rooftop units. They're just DX. That's it. That's it. Right. They're just rooftop AC units.
Did you write the letter that's in the application? Did you write the engineer letter? There's a letter from an engineer in the application. Who wrote that letter?
Structural letter?
Yes.
Yes, we have a certified structural engineer.
But that's not.
Correct. We don't do structural. So we
Okay.
hired Sutton Kennedy to assess the.
That letter didn't help your application at all because it said everything's good. Your issue.
Well, everything's good if you don't put the screens on.
Correct, but that, the letter didn't say that.
Okay. I apologize for, this is the problem. This is the problem that we get weight over capacity if we put the screens on there. So looking at the budget, and I know it says that the budget can't be the only reason that we do this, but it's going to cost $500,000 to do this, to go in there and upgrade the structural. And it's not just that, it's the disruption to the school, which I'm going to let Jason kind of talk about from CMS's perspective when I get through this. But I mean, if this was 10 grand, we'd do it in a heartbeat. But $500,000 of taxpayer money to screen units from view, that's the big problem. And what's peculiar to this property? It's a school. I mean, if this was my office building, we could send everybody home for 3 months while this was all getting done, but we can't do that with the school. School has hours. Okay, so you should use the summer. Well, we tried. We submitted this in time to do this work over the summer, but now we're a month in, we haven't been able to do it. If we can get the variance, we can finish this. And again, Jason will talk about why that's important for this school and other schools kind of moving forward. I do see the point that John makes about it applying to other buildings, but I do still think this is a peculiar to this property because it is a school. Not a result of access to the owner. Why are these units bigger? If we could go back in time and buy these units in 2010, we'd have no problem either. It was the DOE upgrades that happened on January 1st, 2023 that outlawed certain refrigerants and just made, you now need 6 tons to get 5 tons of cooling because of the restrictions that they put on. That's why the equipment is bigger and heavier and looks different than it did. It also created electrical requirements that differ from what's existing out there. So we've already had to do the engineering updates to get more power up to these units in order to make them work to begin with, but that is why they exceed the capacity of the original roof structure. When you say they should have planned for that, in 2012, we didn't see that coming. We didn't know all this was going to happen. I mean, 17 years later, you're going to replace the units. You think you can go like for like. It's never seen a DOE upgrade that caused this much of a disruption in how big these units are. But this had nothing to do with CMS. It had nothing to do with anybody else other than the efficiency upgrades that came through the DOE. And I want you to notice that there are no businesses, homes, anything along Hamilton down here. And the homes that are along Smith, that's the rear of those homes. It's not like these people are walking out their front doors and seeing this. This is what's behind them. And there's also, some vegetation or such over there. But I've got a few different pictures that kind of showed, these were just taken a couple of weeks ago when I sent my colleague out there to take a look at these things, but I just want to lean on that the trees screen the units pretty darn well. There's one spot that they don't, and I want to look at that a little bit more specifically, but this is the view from Hamilton. I mean, you can barely see the building, let alone, I mean, it's just this small piece of it that's on Hamilton that comes down here, but I mean, kind of looking up, there are a lot of mature trees on the back. There's some other smaller trees that are growing in too, but I mean, that's what you literally see from Hamilton when you're on site walking up there. Then we looked at Smith from the neighborhood side and from the school side of the site. And to me, this is just a more accurate depiction of what's going on there, is what you're seeing is mostly those trees and not the units that are sitting above there. From the Smith Road side, it's even more blocked by the trees because the trees are closer to you. So
was this the vegetation option when you referred to the earlier?
That's when I said, if we can use vegetation on the ground, why can't we use vegetation on the roof? Because it seems to be, and again, the diagram given of the ground is not, I agree that it says architectural element, but that's why we're asking. So this is the one spot that it is very visible. Smith kind of slopes up to where the front entrance to the building is. These are screened and they're obvious. So, I mean, I can't wrap my head around spending $500,000 in taxpayer money to have this instead of that. And this is a different school, but it's got a similar design, but these units are not screened, and you can see those up here too. It's a little more obvious that those are rooftop units, but I mean, it's pretty obvious what those are. I mean, they don't exactly match the other colors that are in there. The massing doesn't really do it, but that's what we're looking at.
I refute the notion of taxpayer things, so my taxes are being hit either way. My question is, from a weight standpoint, and these are larger, heavier units.
Right.
If you add those and add the heavier fence that goes around it, is there from a long-term standpoint any detriment or anything to the roof where it starts to give in? Or is the roof stable enough to handle the increase of weight?
The roof is stable. It's the structural system that would need to be beefed up. So that's a very intensive process in the building. We would need to hire a structural engineer or again, get additional services from Sutton Kennelly to address what these units are and go in and beef up the structure inside there, which is tearing out ceilings and doing all kinds of, and like Jason will tell you, it's going to push the project back a year if we do this. And this is something that we got under contract to design this a couple of years ago, but they kind of wait till they actually need to do it. And now's the time that we need to do it. But that's why we're kind of here. Maybe at this point, it'd be a good idea to turn it over to Jason and let him, speak about this from the CMS standpoint, because it's going to fill in a lot of the gaps that I've kind of left.
Yeah. Hey guys, appreciate you staying away long enough to hear us. I know it's been a long day for everybody. So,
I have to have it for our recording.
got a now
It's great.
Okay, good.
Yeah, green's good.
All right, guys. Again, I appreciate you taking the time to listen to us today. My name is Jason Crenshaw. I am the senior mechanical engineer for Charlotte Mecklenburg Schools. Been with the district now for about 15 years, going strong, hopefully. I'm a terrible public speaker and I get nervous, so I figured I'd type this up and write it down.
We're all friends here.
Yeah, we're all friends. You can just have us pass us along on the variance and we'll be out of your hair and you guys can be gone by 2:30. But, when I first became aware of this ordinance, my initial reaction for the screening requirements seemed manageable for typical commercial settings. For a private business, this may be a one-time expense you could, spread across the life of the entire building, or at least a 10 to 12, 15-year life of the rooftop unit. But just for CMS, this is just a very different reality. CMS is not a single commercial building. We operate 200 schools and admin sites. We have approximately 34 million square feet of conditioned space throughout the county. And is manageable at one location becomes significantly more challenging when applied across a district of our size. In response to the recent, like we were discussing earlier, some of the some of the changes in refrigerant have kind of shifted our hand as our focus on what we, primarily focus on. Normally, there's a lot of HVAC equipment out there, but we've unfortunately had to shift more towards aging rooftop units with antiquated R22 unit refrigerants that we can no longer, basically they've priced out the cost. I mean, the cost is it's cost prohibitive, I guess, to keep these R22 units in place and try to run them and try to repair them. The cost for R22 refrigerant has basically quadrupled. over the past few years, and their phase are not completed to a point where we'll no longer be able to get R22 refrigerant, and that's just what these machines. Same with Berwick. The reason we showed Berwick is it's basically the same school, and it's built at the same time, and it doesn't have screenings, and it kind of looks the same. And from me to you guys, those screen walls, we're going to typically leave them open anyway, just because that's the nature of how HVAC technicians work. It's fast, it's furious, 100 degrees on the roof. So they'll be up there. If we put them up there, they're going to be open. Our guys are pretty bad about not closing them.
Are you knowledgeable, Jason, as to why the Barrett Elementary was able to get the units without the fencing? Was that just a variance that was passed?
It was my understanding at the time in 2012, when these schools were both built and both open, that it wasn't a requirement. And actually, if you go up there and look at the roof,
The frontage, that, to me, that's the main difference is it's not visible from this road. Like if you go to that road and how do you get the street view to jump in? But it's not apples and apples because this is kind of off the beaten trail, off this entrance where Rivergate is right on the corner. You see what I'm saying? That's the difference between the two, in my opinion.
Jason, what percentage of schools are in the same boat right now? That over the next 5 years, what percentage of schools are going to be in this boat?
And in this exact situation, it's hard to say, probably 45%, I would say.
So we have a chance of dozens of schools coming in for variances for this?
Yes, sir. Yes, sir. Because basically we have a window. RTUs are big. HVAC RTUs are not a good option for HVAC or for CMS and school districts. So basically we tried that for a little while. We realized it was not conducive to our operating sphere. Sorry, again, I'm terrible at speaking in public. And so we quit doing that. But in that time frame that we were doing it, and that was our main construction direction, these were large RTU units with the R22 refrigerant that's now being phased out. So basically everything that we have that is a school that is all only rooftop HVAC units will be this exact situation. We'll have to come in for a variance, and we'll have to basically be on the hook to either screen for the estimate was $400,000. And that, to me, I know we can't use money as a, excuse for not doing it. But you also got to ask yourself as a realistic person, does this make sense? I mean, come on, does it make sense to spend that kind of money on screenings where we showed pictorially that there's not, if you're far enough, I mean, really, if you don't know HVAC and you don't know buildings, I couldn't tell you whether that was our HVAC unit with screenings or without. And another thing, I just want to continue down through here before I get too sidetracked and sound crazy. Also our capital funding does make a difference for us. I know you had touched on, taxpayer money, they're going to get it one way or another, but our capital funding is finite, which means, we have a limited amount and we're given a certain amount each year. And when projects experience substantial increases in cost and complexity, those impacts do not remain isolated to a single school, because we're the whole district. We're 200 buildings or 600 buildings and 200 schools. So, this single school project has ramifications that will reverberate through the entire district. This creates a cascading effect that could delay, defer, or cancel any planned projects moving forward. The impacts extend beyond just these rooftop units in this project that we're referring to here, and affect future replacements of boilers and chillers and pumping systems and building automation systems and infrastructure improvements throughout the district. Rivergate, unfortunately, this is where it gets to real for me as a building operator. Rivergate's facing an immediate operational challenge. 2 of these units right now are not running. 2 of the larger units that serve, one's for the admin and one's for a classroom wing. So they are down completely. Unfortunately, they're requiring significant repairs, and those repairs are becoming increasingly uneconomical when compared to replacement, and no longer represent a good value for the taxpayers when replacement equipment has already been paid for and procured. Basically, we've been asking the school to kind of bear with us for the past couple of months while we limp these units along, resetting them almost daily, because we knew that this project was going to happen this summer. So we do have the units on hand in a crane yard in Charlotte. That's another unfortunate aspect or angle to this project. If we do not get to move forward, what do we do to keep those 2 units, which actually is a 6th of the school running for an entire another year. And then, how do we secure these units for a year without being damaged? Because we'll have to store them somewhere, and we haven't a spot for that cost as well.
Ms. Inman, I'm gonna ask you a question, it's gonna curl your hair, you ready? Does this board have the ability to put a limitation or a condition that includes the time?
I mean, legally, the condition has to be reasonably related to the variance. So
Let me give you a hypothetical. Hypothetically, could we say we approve the variance and they have 20 years to get the screening installed?
I'm not aware of anything that would prevent that. Kind of be like a,
The trickiest part would be a matter of enforcement and what would be, let us know as city staff to be able to confirm that that has been
20
achieved.
years from now.
Whenever that period happens or whatever the time period is, how do we then know so unlike the other cases, we sometimes will put a zoning hold on a piece of property so that, if there's a future permit pulled, that permit is put on hold until we can confirm that whatever that hold was for was resolved. So it would probably need to be tied in with a zoning hold because otherwise there's nothing that would trigger us to then go back and make sure that they've done it.
Attached to a hold. I don't want it to be attached to a hold. I think we have a serious issue coming to this board, because he's just said 45% of the schools are in the same.
Can I clarify that though? Let me make 2 points, and John, you can tell me if I'm wrong about this. CMS got away from designs like these around 2012. So there will be a finite timeline that there aren't any rooftop replacements that we're dealing with again, because they went back to the chillers. So buildings built after about 2012, 2013 aren't going to have this issue because their equipment is inside. Secondly, I believe if we were to have this same issue at Bearwick, we would not have to go in with screens because the existing units aren't screened. Did I hear you correctly? In the question, why did this get to John's desk? Because we pulled the screens off. That's the only reason I think they saw it. If there weren't screens and we went back without screens, I believe the direction we got from zoning was that would have been okay. So when we do this on Bearwick, we don't have to put screens on. The only reason we're here is because the existing units have screens on them.
So it would be a non-conforming site element. Non-conforming site elements can continue unless you do something that triggers compliance with ordinance. So that would usually be an addition to a building or a construction of additional principal or an additional accessory structure or construction of a whole entirely new principal structure are typically the things that trigger compliance. There are certain exceptions, but generally an addition to a building would trigger compliance with code requirements.
But you're not going to see 20 more variances. You might see 2 or 3.
We can't change of policy in 2023 as a hardship because that's what's triggering.
Correct.
Larger device. Otherwise, if it wasn't for that policy change in 2023, it would be able to replace these units with the exact same units.
Or if we could buy units that were built in 2021 or 2022, but people beat us to that punch. All those units were gone, 6 months before the DOE thing went into effect. There was a time you couldn't even get big rooftop units because everybody knew this was coming and this was going to cause a problem across everywhere. But again, when your funding gets, allocated, you can't pre-purchase all that kind of stuff. And that's why we're here.
Would that policy change be a hardship?
I think that's up to the board if that's a fact that supports your conclusion. And I do think that variances I think there's a case where there was one that had an expiration date. Let me look at that.
Well, I think that this case is unique compared to all the other cases that we've heard, because this deals basically with public money.
Correct.
School system, it's public money because we pay taxes to support our school system. It's not like it was a business that is self-sustaining and can, borrow the money or whatever. I mean, the school system is limited in what it can do because it's a publicly funded entity. To me, that makes it, that sets it apart from some of the other rooftop. If it was a commercial building with this rooftop and we said you had to do this, to me, because that's not taxpayer money, that's individuals' money. And to me, it's a different light because this is a whole different pot of money in it because, and I mean, maybe that's something we're not supposed to consider, but I think that's what sets this apart from when you talk about all the other rooftop buildings in Charlotte. Like, for example, if they had to put it on top of this government building, because this is taxpayer funded building, we pay taxes to support it, right?
The
But you can't do money, I know you can't do the money
That's why I'm
thing,
taking
but
the time. First of all, guys, we're trying to help.
Understood.
The board's trying to help. And so that's why I'm trying to see if we can, if there's a timing, if we can throw a timing issue on it that says you have 20 years to conform, go away. You'd be happy to go, right?
Absolutely.
You think that'd be fine. That way, if we do have 40 schools that come to this board in the next 5 years, we can waggle our finger at you and say, well, we gave them 20 years for a reason, blah, blah, blah. So I just want to see if there's a way around this that would not put staff in trouble and put this board in trouble.
Right. And again, we're not trying to put you in a position that I get the thing about setting a precedent, but I agree with Deborah that this is a special case. This isn't, something that can be financed. This is taxpayer dollars. And if you look at the costs, what the units cost was like $800,000. We're paying a 2/3 premium that could get us 2/3 of the way to replacing all the units on Bearwick when that needs to happen. And just the balance of taxpayer dollars versus bang for your buck based on those two pictures and how much difference there are between those two. Yeah, that's the standard of care as an engineer that I have to bring here, right? I mean, we have to be stewards of owners' money, whether it's private money or public money, but I feel much more about it when I'm a taxpayer in Mecklenburg County, and this is the situation we've got. And again, we are form follows function people. We're mechanical engineers. There's no architect on this job, right? This is an equipment replacement. So, we didn't have the likes of Hamilton to help us through this, but yeah, that's just kind of where we
the
stand.
current screening that you have up there, that you took down, you can't put that back up because of the weight issue? Is that what you're saying? That now that you've put in this new tonnage of air conditioning unit, the screening puts you over the weight limit for the roof? Is that what you're saying?
They physically wouldn't fit as well.
Correct.
I didn't mean to step in, but so the way they did this school is a little different to me. Like I said, I've been doing this for a while, but the screenings aren't really part of the unit. They're not really part of the building. They're just in this little weird gray area where they kind of went up and bolted these things directly to the unit. And that's a no-no as it relates to warranty, especially with these, as these units progress and how technical they become and how advanced they are. Obviously, they cost more money, so that voids your warranty pretty much directly if you were to attach anything to them. So that's why we really can't. If we could have gone back with the other units when this all popped up, that was the first thing. Can we go back with the existing screens? It's a no-go. These will not work at all. Period. That was our first, because we want to comply. We want to do what's right here as well. But unfortunately, these wouldn't work. And then, as we were going down the rabbit hole of what would work to be in conformity and compliance, that dollar amount just started to grow a little bit. And, speaking a little bit to what Jeff said, it's, if we are put in a position where we have to do the 400,000, I mean, that money's going to come from next year's projects. So, I mean, I have to have that discussion with the principal of the school next year, and he or she may be in the same situation where, they see on my projected project list that they're getting a school full of brand new HVAC equipment next year. And then, I have to go talk to them and tell them that's just not going to happen because we had to reallocate funds. I mean, that happens as well, but that's a very difficult conversation to have with school staff, especially this building opened in 2012. That's a long time to run HVAC equipment on the roof. That's
Sorry. No, go ahead, Mr. Shea.
getting to the end of life there.
This is a 2 or 3 day crane operation.
Yes, sir.
3 days.
We try to do it 1 to 2 days.
Wow.
Yes, sir. We've actually done it, and we've squeezed it down to 1 day. A school like this, we could probably do in a day if we didn't have any staff in the building. If the building's occupied, it's a little bit of a different. We'll have our mechanical team go out and disconnect everything, so that they're ready to pull in place. We did a 6-story building right near the airport here in Charlotte, and we did it in a day. So it's doable. We just have to make sure that we get that's the problem too. If we were to, you know, because we did bid this project with, you know, very few crane pulls in the price. So if we were to do a, you know, onesie twosie, because we have 2 units down, we have to replace them, so we have to figure out something to make that right by the time. We got a month till school opens, so we got to figure out something.
Oh, no, you're good, you're good. I think my notion is more so for discussion.
Okay. Any other questions? Or anybody else want to make a comment, gentlemen?
I feel like, the hardship being a result of strict application of the regulations, one we can address. I think the hardship resulting from actions taken by the applicant, the property owners, one we can address. Spirit, intent, and purpose, we could probably address. So I think we need to talk more about, peculiar to the property, location, size, or topography. So, do you,
We're not
are
deliberating
there
yet.
questions centered around peculiarities to this property that we can?
No,
make
we
sure-
gotta, we gotta finish them before.
That's not the property,
start our
this
discussion.
property. This property, peculiarities to this property, and the specifics listed are location, size, and topography. Are there other, are we limited to that criteria?
Well,
I mean, we
there is
gotta,
there is peculiarity to this in the fact that the roof structure will not handle this load.
That's every school.
no, I
Full
have
schools in
some,
the district, not this property.
I have some points to this too, particularly number 14, but
Are different. Sometimes they put a 50% safety factor on things. I've never seen one be this bad. And I don't know if that's one company versus another and what their safety factors have been, or, you know, which one had kind of erred on the side of either conservatism or, you know, aggressiveness. I do know that there was a lot of VE on this job. The parapets are supposed to be higher. They got VE down. There were supposed to be parapets on all sides and they took them out of the sides and the back. So
Still, the elevation with the original.
I move that we kind of go into discussion as a board, because I think from a fact standpoint, we understand. I just think we need to discuss this as a board, because I think we're all in the same arena of thought and train of
the
thought.
taxpayer money piece of it is peculiar to this property. I mean,
Well,
could that
that-
be the reason?
That
we-
couldn't be
really can't
that can't be an argument.
Personally, no, we cannot
Okay.
consider money. I mean,
And then just what I put up there about
I
it's
brought
not
it
an
up,
office
but-
building where you can send everybody
but
home.
no.
Well,
The fact that
I'm,
it's a school is peculiar to this
Bad girl.
property. I don't know.
Okay, any other questions for these gentlemen?
I have a question. What
Yes.
else besides the financial impact do you feel supports your request?
Just the fact that we'd have to wait a whole year to do it and it screws up what CMS is allocated for this, and it pushes a project that was supposed to be done next year out another year, and there's just a, you know, cascading sequence of it. And the fact that, you know, because it's a school, you can't send everybody to work from home for a couple months while you do it. It would push it the entire year in order to do that. Does that answer your question?
instructional disruption.
I have a strong argument. Once we get into deliberations, I have a strong argument as to why there is a hardship not created by them, but I'll bring that forth when we get to that point.
Well, and I think it's okay for us to talk about the peculiarity of this property. You know, we don't need to think about all the other properties, but peculiar to this one is the structure of the roof. And that the structure of the roof at this point in time does not support adding these coverings
But it does.
without additional structural work underneath.
I think the biggest hardship, again, is the fact that the policy changed in 23, but let's
We
get there.
close the
Yeah,
hearing.
we will.
Yeah.
Okay, thank you, gentlemen. You may listen to, all right, we'll now go into deliberations as a board, as long as there's no more questions for staff or for these gentlemen. Anybody?
Nah, my understanding of this is this thing would be clear cut, dry, simple. The city would probably have this on the recommendation list if it wasn't for that policy change in 2023. That policy change created a issue where a building that was built in 2012 now does not have the ability to support the same systems that's on the top. That policy requirement is what's forcing the engineering group or CMS to buy the larger units, which are heavier in weight and will require new fences. I think if it was not for that policy in 2023, they would have the ability to buy new units that could fit within the existing frames, and we wouldn't even be here. But because things did change in 2023, we're here. That's the hardship right there, because policies changed 11 years after this structure was built. Now they have to bring in new units that are applicable to the said policy that wasn't in place when this was built.
And whose policy requirements for those? The
DOE, Department of Energy, yes, ma'am.
Okay, thank you.
So we could do the same thing. Well, let me ask Paige. We could do two things, right? One is Hamilton, you were talking about the conclusion of law. We could boot that to next month as well.
I think we concentrate on the last four conclusions of law and talk about those. And then we can use that as the outline to reframe the findings of fact.
So I think where Mr. Shea was going, we approve the variance and we defer the conclusions until the next meeting.
We have to confirm the conclusions of law.
Right.
So for number one, it says unnecessary hardships would not result from the strict application. So that's got to change to hardships would.
Mhm.
No.
Yeah, I think if the board can talk about the facts that support
Right.
each conclusion, then yes, we can defer the findings of fact. We can bring a draft
Okay.
back to you.
So the unnecessary hardships that would result from the strict application of the law or regulation, in addition to the additional cost, are instructional disruptions that are unique to a school that would be required to remove ceilings, add structure, and deal with all the construction related disruptions and continue instruction.
And if not, that a third of the building would be without air conditioning. Because two of the units have already failed. And cannot, and
So number two, then, Hamilton, you thinking the hardship does result from conditions that are peculiar to the property, like we're talking about?
So yeah,
specific to the structures.
I mean, location, size and topography, or I don't know that there's anything specific to those, but I think if you talk about the things that are specific to this piece of property and this building, that the
roof
steel structure that
the
has been constructed.
if current conditions does not support
Yeah.
the screening.
Right.
A typical rooftop unit replacement, you would not typically assume you would have to do as extensive a structural reinforcement as this. Most buildings are not required to do this much structural this remediation.
So then we said for number three, the hardship does not result from the actions taken by the applicant, back to Gary's point.
Yep.
Because of DOE changes in 2023.
So the hardship does not result from actions taken by the applicant
Or the property owner.
or the property owner
Due
to DOE.
2020.
So in addition
But
in addition to policy changes and department, because department, I mean,
Yeah.
policy changes and regulation upgrades are pretty common. And I think that's definitely a hardship, but I don't think we ought to limit that. I think we need to add some things to that.
The hardship does not result from actions taken by the applicant or the property owner, but because of DOE policy passed in 2023.
And specific conditions to this property.
And I also think that there's some, and this is a little, so the school district is not currently one of my clients, but they used to be, and I designed some schools for them, and they lost a bond referendum in 2005. And in order to pass a bond referendum, they had to put together a committee to make suggestions on how to make schools less expensive and pass a bond. And one of the line items on that was, do not put rooftop screens on rooftop units. It was mandated by the voters of, it was mandated by a commission, a special commission put together by the superintendent to pass a bond. So like there are Those are actions that weren't even created by the school district. Those are actions that were taken by others to put them in a situation where they were not allowed to anticipate rooftop screens.
Wow, that's interesting.
So just a heads up, though, that's not an evidence, so you can't consider that as part of your decision.
Well, I think, but as long as we reference maybe policy requirements enacted in 2023 would suffice, and specific conditions. And then the requested variance is consistent with the spirit, purpose, and intent of the regulations. Okay, because especially with public safety, because you've got to have the air conditioning units working for public safety, because you can't have people in the classrooms having heat stroke.
Yeah, kids can't learn in the heat.
As a former teacher, I can attest to the fact that you do need air conditioning in a classroom.
So Ms. Inman, do we have the ability to do a time?
Yeah,
So I think that you can create that as a condition.
as a
and then
condition.
After the expiration, it would go back to the provisions of the UDO. John, Terry, if either of you have any suggestions on language for that.
Why do we
but
have to include?
I can't guarantee you, I'm not aware of any legal authority necessarily directly addressing that without doing some more research. So I can't guarantee that that would uphold.
Because surely within 20 years, we would be beyond this.
I do think.
Well, I mean, why would we need to add a time frame instead of making this just permanent?
Because we
I
want,
think it just overly complicates.
Yeah, I think just if we pass the variance and grant it, it's a permanent fixture for this property. I mean, we can't use precedent.
The intent of the suggested condition is is your intent to try to basically allow it for these specific units this one time, but then later down the road, if they need to replace them again, that they'll comply with whatever the standards are at that time period? Is that the intent?
The other 40 schools. I'm worried about 40 more schools coming.
So we wouldn't be able to apply a condition that would be applicable to any other property. It all has to be only applicable to this specific site.
But as Terry and Paige are going to think, why would you approve this and not approve that if this went to Superior Court? What was the difference?
I'm gonna be honest, Mr. Shea, we heard a case earlier today and I was telling Marshall, one of the arguments was the Catawba River watershed, and that was one of the reasons it was granted. But I argued about a landfill around the corner from my neighborhood, which was in the same area as that variance, and that wasn't taken into consideration when members voted in favor of it. So I mean, to your point, it's one case versus another. It's an individual case by case basis.
but I think what John is saying is that if we because we're dealing with this case in this particular school, the only place that we could apply the 20-year limit would be for this school at this time, not for any other school
Right.
that came before.
But I think John's other part of his statement or question, because he had a question, was why? Why the time limit? Because we wouldn't be able to use that for any other schools if that was the rationale. To my point, if we grant the variance, it's permanent, it's done. We don't have to go back on it at any time, 20, 50, 100 years.
I'm only,
I know what you're trying to do. You're
If precedent worked, right?
Umbrella, the other 45 schools that might have to come before this board. What Paige is saying and what John is saying is that that's not going to be able to apply, because what we do here applies only to this school. You can't apply it to something that's going to come up in another school. They'll have to do another
and
variance.
if you guys are comfortable, that'll be cool.
Okay. All right. Go ahead.
Some motion to approve.
Okay, so we have a motion to approve this variance.
And I
This
second.
son,
I second that motion.
Mr. Young seconds with
Conclusion.
the conclusions of law and
I think we're.
Well, we're
to
good.
be deferred
Yes,
for the,
right.
yeah.
So just a motion to approve the
All right,
variance.
so a motion to approve. Okay, Mr. Young,
Young, yes.
Mr. Shea,
Shay, yes.
Ms. Sun,
Yes.
Ms. Court,
Court, yes.
and Dryden, yes. So we have voted to approve. And now I need
I'll move to
Motion
defer. I'll move to defer, findings of fact and conclusions of the law until next month.
Okay, thank you, Mr. Court. Ms. Sun, you second. All right, Mr. Young,
Young, yes.
Mr. Shea,
Shay, yes.
Ms. Sun,
Yes.
and Mr. Court,
Corey, yes.
and Dryden, yes. Okay, so just to be clear, board, we have deferred 3 finding facts and conclusions of law till next week, next month. At this time, we need to vote on the minutes, please. From the last meeting, were there any additions or corrections that anybody saw? If not, I'll entertain a motion to approve the minutes.
Court move to approve.
Thank you. Do I hear a second?
Second.
Thank you, Ms. Sun. All right, before you leave, thank you, gentlemen. I wasn't talking to you, I was talking to the board. Board, at your disposal, you need to elect a new chairman. As this is my last official meeting with this board, I want to thank everybody here. I've appreciated my time. I've been with this board for 6 years. It has been my pleasure to serve the community. And I leave with a smile on my face, but I've really, really enjoyed my time here. I've learned a whole lot. So do I hear a nomination for chair?
Yes, I nominate Mr. Shea.
Okay, Ms. Sun nominates Kevin Shea. Do I hear a second?
Second.
I second. I third.
All in favor, say aye.
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 All right, Kevin Shea, you will. My goodness. Oh, you're so kind.
Years of service, we wanted to present you with a little
Oh,
a gift of appreciation.
oh, look at that.
Supposed to be hearing this.
Well, that is so sweet of you. You're so kind. I really have enjoyed it, and you guys have all been a joy, and I've learned a lot from Kevin sitting here as he goes. Very nice. So y'all be sure and give him the same heads up when he. Oh my, what's this? So for my travels, oh my goodness. Yes, I will be traveling. I'm having my knee surgery on August the 4th. So by October, I will be up and around and my grandson gets married. And it's so much fun. I'm so happy to have that done because the guard at the front, when I came up the steps, he went, I didn't know you were doing cardio today because I had to stop at the top of the steps. And I said, oh, well, I just had to get my, because my knees, I just can't do stairs anymore. I left when grinds every time I do a step. Oh, look at this. Is it a journal?
Yeah.
Oh, how lovely. This is what every teacher loves is a journal to keep me in touch. Oh, I love it. Thank you so much. Oh, I will certainly enjoy this. And God willing, I'll serve on a board again. Thank you all so very much. I've enjoyed it, every minute of it. Thank you, thank you, thank you. All right, this meeting is officially.
Wait.
What?
One thing before we go. First of all, appreciate your service. Thank you. It's been a pleasure. Mr. Shea, so the rules of procedure provide that the chairperson serves for 1 year, beginning on January 1st. A little late. I would suggest that we make Mr. Shea's appointment through the January 1st, which time we can stay on the rules of procedure schedule. And then we need to also select a vice chair. So if you agree with that in regards to Mr. Shea serving through January 1, then we need to motion to amend the previous motion to appoint Mr. Shea as chair through January 1. No, so like you would serve until January and then we would reelect either you again or someone else for 1 year. That makes it consistent with your rules.
But we're adjourned since the board changes over in July. Well, I guess too, because I'm going off.
She would.
I don't disagree, but the rules of procedure say chairperson's term shall be for 1 year or until a successor is elected beginning on January 1st.
The devil was illegal.
Y'all could have kicked me off a long time ago.
Sticking with the word,
I don't know.
that's my suggestion. You don't necessarily have to proceed in that manner. If no one wants to make that motion, then.
So we gotta make a motion to do this over, voting this kid to the.
No, we don't have to.
No.
We don't want to.
Okay,
Yes.
look, I'll make a motion to approve Mr. Shea as chair for until January 6th, when he could possibly be reappointed as at another voting time. All right, and you need a vice chair. Do I hear a nomination for a vice chair?
Can we finish that motion, though? Do we have a
Oh, okay.
second?
Do I have a second for that motion?
Second.
I said
Okay.
yes.
Dryden and then soon, okay. So, so the motion is to appoint Mr. Shea as chair of this committee through January the 1st, where he can then be appointed again for a year's time. And that was seconded by Ms. Sun, Mr. Court,
Court, yes.
Ms. Sun,
yes.
Mr. Young,
Young, yes.
Dryden, yes. Okay,
And Mr. Shea.
and Mr. Shea,
Do I have to say this?
yes, you have to say yes.
Okay.
Okay, so Mr. Shea is appointed as your chair until January the 6th. All right, do you have to do,
And then we need a nomination for a vice chair.
okay, a vice chair?
So when do we know when people roll off? And as the vice chair have, I've been vice chair for 3 years too, there was no time limitation.
Oh, no, that's great.
2027.
So.
Six.
I served a half term, so I don't know where I am.
Yeah, I have no idea in terms of.
It would make sense to me to do the vice chair through January 1 as well, and then you would elect
Right.
new officers.
And that,
Same
I mean, the
officers.
vice chair is just, it's who takes over when the chair's not here.
Right, but he was vice chair, so
Yeah.
now that seat is vacant.
That seat is now vacant. Okay, I make a motion to approve Hamilton, to suggest Hamilton Court to be the vice chair.
I second.
Okay,
Son, yes.
vice chair is Hamilton. Okay,
Here.
got it?
Yeah.
All right. Dryden. Okay,
Can we amend that motion to say until January?
yes, yes, to vice chair until January the 2nd, when we will again vote on all these positions. All right, Mr. Young,
Young, yes.
Mr. Shea,
Say yes.
Dryden, yes, Ms. Sun,
Son, yes.
and Mr. Court.
Court, yes.
And that's
Okay, so now you have a new chair, Mr. Kevin Shea, and a new vice chair, Mr. Hamilton Court,
Through
All right.
January 1.
until January 1 of 2027. Okay.
Oh, wow.
And who has that?
Are we concluded?
Thank you.
Yes, we're done.
I got
Thank you, Elizabeth. It was nice getting to know you.
Did we adjourn?
Yes, we are adjourned.
Okay.
Well,